That was my seat.
So each of you just took her seat.
I'll sit with Shelley.
Oh, Sheila.
You're good.
No, that's fine.
I can't talk there anyway.
Now you're good. It catches every curse.
Mm.
And then that translates into type about 90 different languages. I'll type in a minute.
Looks like I did it. It's not.
So really,
I can impress them, you said about me.
I can do that.
Well, what's the difference? Has everybody signed in? If you have not signed in, you will not be able to speak if you're asked to speak, or if you have any, whether you're the challenger or somebody being challenged, you have to sign in. Okay, hearing no objections there, I'm going to go ahead and open the meeting. We'll call the meeting to order, and we will start with the Pledge of Allegiance. Did you? Oh, got it, okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, in case you don't know, I'm Tony Volker. I'm the chairman of the board. This is Mr. Frank Coffin. He is our vice chair. And this is Diane Stutzman, our secretary and clerk of court. I have asked our counsel, Mr. Richard Lorenz, to make an opening statement, and he will do that now before we move on to the next phase.
Okay, very briefly, ladies and gentlemen, welcome to this proceeding. My name is Richard Lorenz, and I've been asked by the County Election Board only this past week, actually, to assist in the conduct of the hearing regarding the challenges to several candidates in the primary election. Previously, I've acted as county attorney for some 20 years and have worked as an attorney for 54 years. I've got a broad range of experience in municipal, governmental, and administrative law. I'm not here to make any decisions for the board, but merely as a quasi-moderator and parliamentarian to help direct and focus the inquiries that we have today.
Mr. Lorenz, I'm sorry, I'm not sure your mic is on here.
Okay. First, let me say that this is a hearing where probably no one wants to be in attendance, but it is required for the board to hear testimony and consider the contentions and the allegations that form the basis of each challenge. We would ask that you respect that the other people in the hearing and confine yourself to the facts without any personal attacks. This hearing will be informal, and the rules of evidence used in trial proceedings will not be applied. Conversely, there's a need for the organization and direct inquiry into each candidate's filings. Each candidate will be called and sworn in, and then the board will ask the candidate to stipulate and validate the documents that have been filed as true and correct, so we all have the same working starting point now. Then the specific challenges will be taken up one by one. They're in many subparts in many cases, and also there'll be several lines of inquiry. After the candidate is questioned, then the challenger has the opportunity to present any additional materials or to form a further basis on what she wants to comment on. The candidate should realize that the contents and substance of their forms are their responsibility, and that the clerk is essentially ministerial and acts as the repository of the filed documents. Neither the clerk nor the board is authorized to offer any legal advice, and each candidate and challenger is entitled to use their own legal counsel if they desire. In many of these cases, the challenges are technical and will require explanation or clarification of the actions or omissions of the witnesses. The board has some discretion on some issues and no discretion on others. The testimony, evidence, and state statutory requirements are controlling. There are 9 candidate challenges, and most of those contain multiple elements. The board will address each of those elements and render its opinion. Because of the volume, we will require some time for the organization of a prompt written set of findings of fact and conclusions of law. There will be no decisions announced today or debated today. The hearing will continue as per the notice until tomorrow at 9 a.m., at which time the members will discuss, debate, and render their findings of fact and conclusions of law in open public session. Once the hearings are concluded today, the board members will not converse with each other outside the public hearing until the session tomorrow. I will assist the board by providing the universe of possible findings and conclusions that they can make applicable to the facts that are presented today. Both sides, of course, have the opportunity to appeal the decision of the board within 30 days of the written opinion by direct appeal to the circuit court. That hearing will be an administrative hearing to review the testimony and evidence in this proceeding. Consequently, it's imperative that you speak out loudly today and clearly for the record, and that you include all responses necessary to substantiate your position. I will say that the questions presented indicate a need to reinforce, clarify, and extend the mechanics and due diligence on the part of all candidates, the clerk, and the political parties as a systemic matter. This is called to question how we do business, and we got to look at that. I hope to provide outlines, checklists, and other resources to avoid the types of questions raised in this proceeding today as an educational process. I want to thank you for your patience in allowing these remarks, and I would turn it back to Tony.
Thank you, sir. Okay, first order of business before we actually get into the individual challenges, there was a plethora of information that was delivered to the courthouse, I believe, yesterday. That information was outside the deadline from February 13th when all challenge information had to be filed. No board member has had any time to review that. This will not be allowed or considered in any of the challenges today.
Point of order.
Yes.
This material was provided as a courtesy early. During my testimony today, I am allowed to, at the beginning of my testimony, provide documents and supportive information, which is what I have done. As a courtesy, I provided to you early in that, and the state does allow for an amendment, when the letter went out from the county to each candidate, they included documents that I did not include in my challenge. The challenge references documents, and it's, to me, as the challenger, to provide you copies of those particular documents and the statute and the exhibits, which I am allowed to present during my testimony. So where you say you are not accepting them, then I could agree with that, but they are presentable when I give my testimony as a challenger in support of my statement.
I've not had a chance to look at these additional documents either. I assume that they overlap with things that have already been looked at or announced in the challenges that are already there, okay? To the extent that the subject matter of today's proceeding will be the challenges that are specifically raised by the form filed by the challenger and these attachments that she has with the statutory and additional elaboration on each of the violations that she finds, okay? And that will be allowed, okay? It's not that these documents may not be referenced in a generic sense at all, because she's going to be talking about, I think, overall concerns that she has.
Right.
So you're going to get to where you want to be, I think, even without the documents there.
I will have to reference those documents where you will be unable to follow the degree of my testimony. And the documents I provide, everyone is in support of my challenge. And,
Let's take them one at a time as they come up.
Okay.
John?
Agreed.
Okay, very good. Excuse me. We have one request with us here because of, for medical purposes, Mr. Sam Hobbs has asked if he could go first, and the board has agreed to, or the chair has agreed to allow that, that hearing first. So the way we're going to proceed with this, I'm sorry, did you have a question? The way we're going to proceed with this is each candidate that filed and has been challenged, I will walk you through a process of swearing you in, and then we have a series of questions that I will be asking you, and then there will be time given to the challenger, which is Ms. Rogers, and she will be able to give her response to the challenges. I mean, her reason for the challenge. Okay, so we're going to start with Sam. Sam, would you please raise your right hand?
Why don't you have him come on up here?
Oh, okay. Thank you. Come on up to the front, Sam. Please raise your right hand. Do you swear or affirm under the penalties of perjury, penalties for perjury, that the testimony you're about to give will be true, the whole truth, and nothing but the truth?
I do.
Okay. State your name for the record, please.
Leonard Hobbs, II.
Okay. If you'd like to sit, Sam, that's fine.
Thank you.
Sam, do you have the copies of the documents that you have filed with the clerk of the Owen Circuit Court for candidacy of the primary election?
Yes,
Would you review those documents and determine whether they are true and accurate copies of the forms that you filed?
they are.
Okay? For the record, the witness has authenticated and stipulated to the CAN 2 and CAN 12 and CF 1 as those are displayed in the respective packet, and those are made as part of this record. Sam, are there any errors or omissions on those forms?
Oh, boy. I need to say probably in general, there probably is, I may have missed a telephone number or a town, a town of Spencer or something like that.
Okay. And one moment, I need to get to its actual form here. Okay. Do you wish to clarify or expand on the reasons for any of those errors or omissions?
Yes, sir. I do, to be honest with you. Also on the errors of the CAM 4, I apologize. On the financial part, when I went over and looked through it all, I've been through several elections and paperwork and documentation. I thought the beginning balance was for what I was starting out this year. But clearly that's not the case, so me and my wife have spent the last several days going back through all of the information and have in our possession this morning the amended stuff from the CAM 4s and CAM 12s and everything, and I haven't signed them yet because it's my understanding, I was told that these have to be signed in front of somebody and notarized. That was one of the things that was brought up. So I have all the new forms that we filled out, the things that may have been omitted. We went back through all the way through 2024 and redid the CAM 4, the CAM 12. So I have all that information here.
Okay.
If that makes sense. To be quite honest with you, sir, going through the paperwork, it is somewhat challenging, somewhat confusing at the least to understand how things should be and shouldn't be done. There was no ill intent or deceitfulness or trying to hide something. We got all the bank statements here if anybody needs to see all that. There's just no ill will towards any of this. I don't believe anybody sitting here has any ill will towards deceiving the board, election board, the public, or anything else. Did we miss stuff on the paperwork? Absolutely we did.
Okay, thank you. You understand that a challenger has identified a number of discrepancies and deficiencies that she has observed in your documentation.
Yes, sir.
Okay, let's take those one by one. The candidate, according to the challenge, the candidate did not sign under oath.
If I may assist at this point on this particular one, it appears that the candidate has signed and the oath is identified immediately above his signature, and it does appear to bear the signature of the clerk in this particular matter. I assume, Sam, you read on page 2 of the wording in the bold type that says, "I certify that the information in this declaration of candidacy is true and complete, and I meet the specific requirements of the office."
Yes, sir.
Okay.
Okay.
And the clerk was there at the time that you presented these documents?
That is correct.
Okay. And the clerk, in fact, affixed the signature that she has for her office.
That is correct, sir. Yes, sir.
Okay.
Thank you.
Proceed further then, sir.
Thank you. And Mr. Lenz just pointed out to you that you were aware, or you affirmed that you were aware that the declaration of candidacy is true and complete and meet the specific requirements of the office, or that you meet the specific requirements of the office.
Yes, sir.
Office, okay. All right. Number 2, the candidate did not answer questions 7 through 13. My notes here show that this is Pam's general statement, but it is not correct. All answers are initialed. Pam contests the answer to item number 12. So let's look at item number 12.
Is this on the CF1, sir?
Yeah, this is on the Can 2, I'm sorry. Still on the Can 2.
What number are you referencing, sir?
Pardon me?
Which number are you referencing?
Number 12 is what shows up on the statement.
No, you have 3 pages of my Can 1.
Yes.
This is a statement for that. Which number are you referencing?
Oh, hang on just a moment. You said the candidate did not answer questions 7 through 12. So let me get to the challenge.
13.
Number 13?
Not applicable, but never mind.
No, that's not on there.
And is this on the Can 2?
Yes, sir. Those are scratched off. Placement in the individual primary election. Election candidacy. Yeah, here we go. Number 6.
Item 6.
Yes, item 6.
In your challenge.
Declaration, in the challenge, declaration of candidacy for primary nomination, list of candidate certification highlighted in a standalone outline blocks, 7 through 13, specific questions each candidate must initial and sign under oath. Okay,
As I understand it, the heart of the challenge is her final sentence in the challenge, which says if they answer untruthfully, this is a violation of the sworn statement. Evidence will be provided at the hearing. So that is the basis on which the challenge appears to be made, that the candidate did not file or correctly file past financial reports.
past financial.
If I could make another interjection here, it appears on the candidate to form that the certifications are in fact initialed in each case 7 through 13, and that the challenge, if read broadly, would be one to the answer to number 12.
Yes.
That all reports have been required, that are required have been filed. The answer blocks allow you only to say yes or no. The contention, I think, by the challenger is that they were inadequate or improperly or untidily filed. And that's for the challenger to substantiate.
At some point in the past.
Yeah.
Okay? All right.
So you're on 3.
Yeah, so, Mr. Hobbs, did you have a previous candidacy in which you did not file timely campaign financing reports as required by law?
Yes, the CAM, I believe it was the CAM 12.
Okay. And do you wish to explain the reason?
You know, I have no answer, I mean, I have no excuse for it whatsoever. That's the reason I went back through everything the last several days and realized that we hadn't filed, I believe, the CAM 12 financial report. I'll be honest with you, I didn't quite understand some of it, and, you know, ignorance of the law is no excuse by no means, and I'll make no excuses.
Okay. And this was on a previous election, not this election?
That is correct, sir.
Okay.
And if I may say, I'm sure that as we proceed, there will be things that come up that I don't understand, or maybe need, you know, to ask some questions on myself, because to be honest with you, some of the paperwork is a little difficult to follow.
Okay.
Let me ask a clarifying question. Are we talking about a CAN 12 from a previous, or are we talking about CFA 4?
CF4, I apologize.
Okay,
Okay.
thank you.
Thank you, Frank.
The CAN 12, yes.
When you sign up.
That is correct, yes.
Okay.
Okay, all right.
Thank you,
That's
Frank.
my
And
understanding. Thank you.
Thank you for that clarification,
Yes.
Frank. Do you recall which election that was?
Michelle, do you? Commissioner.
For commissioner? So
yes.
would have been, what, 2 years ago?
Yes,
Okay. Gotcha.
my apologies.
No worries. Let's see, today is, okay, so this would have been 2024 election. Correct? Okay. Other than the form that you missed, or that you've already testified to, were all the campaign financing reports true and correct to the best of your knowledge?
To the best of my knowledge, now, we had to go back through and do some amendments, and we did, and I have those new, we filled those out the last few days.
Okay.
But I didn't sign them because I was told that we had to sign them in front of somebody and be sworn in to do that.
Gotcha.
So I'm confused about that.
I'm going to ask legal counsel, would those be something we would just submit as
No,
evidence
they
of
need
his
to be
testimony?
filed officially and
Okay.
brought to the clerk and all.
Okay.
For
With the
them to
clerk.
be.
Okay.
Just
considered.
as normal.
Okay, gotcha. And the clerk
Outside is here.
rather than a notary, the clerk can take a sworn statement that those are correct to the best.
Just so we don't have any confusion about this, the documents can be presented and signed in front of a notary or brought into the clerk, who also has the authority to attest and affirm for any documents that are required by statute.
Thank you.
But at this moment, those documents remain unfiled, but that can be done at any time. Am I right, counsel?
Yes,
That's
I
it.
have those
Okay.
here, sir.
All right.
Okay.
But they're amendments, am I understanding that right?
Well,
They're changes to previous reports, is that
Yeah,
right? They're
yeah,
amendments to those
There's
reports?
some stuff missing,
Okay.
yes.
Okay, the next thing, the challenger alleges is
You
that,
may ignore that. Apparently, she had stricken through number 8 of her submission.
oh, okay, okay. All right, we'll disregard that one then.
Just for the board's total comprehension, the challenger has affixed to her challenges a series of paragraphs that are numbered. each one with a different challenge for various parts of the various forms that are filed. And she has lined through or circled the ones that she wants to be applicable. And so it's a little confusing sometimes on what those are.
Gotcha. One moment, please.
Oh, okay, I see what you're saying. So challenger's item 8 is not in play.
Right.
Thank you.
Okay, I'm going to read this observation from the board. I believe that the board realizes that the campaign finance reporting has been suffering in this county for a number of years from a lack of due diligence on the part of candidates and even the board in some instances. We will make findings requiring the determination of eligibility in due course in these proceedings, but I think there will need to be additional hearings required to assess any penalty or fine or any referrals required by law as to this issue. The State Election Commission has noted the requirement for separate proceedings for fines and other actions. You may be assured that the board will consider future violations as to this aspect of candidacy as serious and subject to actions that will prevent these violations. Excuse me. And that is going to be a blanket statement for all of the candidates that have filed. Mr. Hobbs, is there anything that any concluding testimony that you would like to give before we move on to Ms. Rogers?
No, I agree with the statement you just made there and the statement that Attorney Richard Lorenz stated earlier. I even went back, Tony, back to the day when I ran before Commissioner, when me and you, and I realized that I think the lack of consistency on the forms and in the knowledge, the public information, not just from the candidates, but from others as well, is something that needs to be rectified and drawled into a sequence that, just like you said, it's A, B, C, and D. And you can't move forward to B until A is complete. I think that's something that needs to be done. I've made some errors. I'm not perfect. Nobody sitting here is. It's not my first documentation that I may have messed up, and it probably won't be my last, but there was no ill intent or no deceiving of anybody. I've known everybody here, biggest part of my life, so just want to let you know this is not something that should be perceived as hiding something under the rug or getting illegal funds or doing this or doing that. That was never my intent, never would be. It's not going to be.
Fantastic. Thank you, sir. At this point, we'll go ahead and dismiss you, and then we'll ask, and I'm sorry, do you go by Ms. Rogers, Mrs. Rogers?
Pam is fine.
Just Pam? Okay, we'll ask Pam to come up and prepare for her testimony.
Good.
As the challenger.
I say just one more thing, then
Yes, sir.
I'll leave you alone. I'm not sure if if I understand everything, so there may be things that she brings up that may be true, may not be true, but we're here to fix whatever's wrong.
Okay, you will be given a few minutes as a rebuttal after she presents her findings.
Thank you.
Okay.
No.
I'd like to ask if I could get a copy of the Can 1 that you referred to, the packet that was sent that still has not arrived. The card was delivered to the wrong mailbox.
You're talking about...
Just on Mr. Hobbs,
Uh-huh.
I would like to check and see if what you read off matches.
What you wrote?
I just wanted to see the Can 1 that you just used in testimony from Mr. Hobbs.
The Can 1 filed by you?
Yes.
Okay.
I
but,
just would like to look at the copy of it that you used, please.
Before we do that, I need to swear her in as well, correct?
Yes.
Okay. Pam, would you raise your right hand, please? Do you swear to, or affirm under the penalties of perjury that the testimony you're about to give will be true, the whole truth, and nothing but the truth?
I do, sir.
For the record, will you state your full name?
Pamela Irene Rogers.
Okay. At this point, is there any reason that we would not be?
Let me help direct this if I can.
Okay.
Pam, you have filed a CAB 1 on this matter, and you have identified several paragraphs that are attached to your proceedings that you reference as the challenges. Is that correct?
That is correct.
Okay. The ones that are lying through are not challenges.
That is correct.
Okay. So let's take the Sam Hobbs case and all. Your first challenge, please be seated. No.
Well, I was going to wait till I could walk up and get to Can 1.
The board each has a packet that contains your CAB 1.
Yes, sir, I was just asking to see a copy of the Can 1 that he just read off. I do not have a copy. The
You don't
packet
have a
that-
copy for yourself of what
Yes.
you filed?
No, I do. I just want to see the document you have.
Here it
because-
is.
I guess, I just want to look at it briefly. Because it may have been just the way in which you read, because some of the information was a little confusing. The Can 1 is not on this. Oh, here it is.
Yes, it is. That's
Here we go,
all.
thank you. Did not.
Okay.
Thank you,
Okay,
because
good
this
enough.
varies slightly from what was announced there. May I read this into record?
No, the board has the record of this, okay? And you will find that sometimes the board's questions, I have drawn together some of the questions that you have posed because they are overlapping, okay?
Yes, sir. Okay, thank
So the information gleaned would be the same if each individual sub-item was used. This will be applicable to other testimony you have.
Thank you. So I'd like to begin by, may I make a general statement?
Please.
Yes.
Yes. Yeah. This is applicable to all challenges today, so just a general statement. The filing of my Can 1 challenges are not personal or political or against any candidate, as several of those I have filed against I would consider friends or associates. The challenges are one of the few tools that the public has to facilitate our future elected officials who are eligible to run, and that they are held accountable for their sworn statements included within the questions of each Can 2. If a candidate swears to having filed all reports from prior campaigns, then this statement under oath quasi-removes auditing and investigation by the CEB for those new Can 2s, as a candidate is certifying that they have complied with the specific requirements. Not until challenges are filed against candidates would or should a CEB standing for County Election Board, investigate. Filing false statements on a Can 2 qualifies for civil and penal enforcements. As both a citizen and a person who recently also filed a Can 2, I expect officials who are running for another term to demonstrate truthfulness, the ability to read and follow instructions, and at a minimum, not to swear to documents being complete and correct when the questions were not even answered. In some instances, avoiding answering questions allows the candidate to swear to the truthfulness of their Can 2 because they didn't answer questions that might otherwise then serve as a statement qualifying for future penal, civil, felony, or other actions. The law provides no opportunity for a Can 2 to be amended after the final filing date. A Can 1 does not prevent a candidate from running for the 2026 election. They have the opportunity to file as an independent with a corrected Can 2. On the matter of Sam Hobbs, I would like to first address the discussion that was made and rebuttal to some of the statements that were made. First of all, before you are packets that I wish to have given to each person. These packets contain the actual documents referenced in the Can 1 I filed, including the CFA4s, the CF1s, and the historical Can 2s that are all applicable to the whole story. And you need this information to be able to proceed. Within each packet, there's also a set of exhibits. These exhibits will be referenced to, that provide you direct correlation to the statute and the particular manuals that are used, the 2026 manuals that are given to each candidate and to the administrator that provides the directions and step-by-step, line-by-line instruction as to how to answer any question, how to fill out each Can 4, how to proceed with managing the paperwork, as Mr. Hobbs admittedly says is confusing. It absolutely is. This is one reason why within the documents that are in support of filing a Can 2, it is directly recommended that each candidate seek legal advice or consultation if they have any questions as how to manage filling out their forms, how to manage addressing amendments, financial information, and understanding the complexities of the fiscal matters in monitoring, tracking, and reporting expenses and incomes of your committee. So I would ask that these be admitted in support of the testimony that I'm about ready to provide. And I believe are these, those up here, these are the ones that,
Yeah, I have it.
okay.
We have it.
And those were given this morning or last night?
Last night.
Yes, I provided those prior to the hearing today, and per statute, I could amend a Can 1, but this is not an amendment. These are a portion of the testimony that I am giving today. Therefore, they are allowed to be admitted today as a component of what I'm about to say, if you can please distribute those. Do you?
I have it.
They all have.
Excellent. So going now directly to Mr. Hobbs, please. In my Can 1, you will find direct reference to the use of the CFA1s, the CFA4s, and supplemental records, as is alluded to in the dialogue that I use in the Can 1. In the Can 1, there is an additional 3-page document. For Mr. Hobbs, my statement is the act of submitting a Can 2 for filing does not fulfill the definition and requirements that a declaration of candidacy for primary nomination in 2020 says 2006, and that is a typo. It should read 2026, Can 2, satisfies this requirement unless the form's information is true and complete. This is the emphasis, that this is what the candidate is swearing to under oath, that the information is true and complete. Number 1, IC 3827 provides that a candidate must sign their declaration of candidacy after swearing and affirming the truth of statements. This was already admitted to and clarified. Mr. Hobbs did, and I admit he did sign his Can 2 as was required to. Thus, this stands as proof that his statement was a sworn testimony to the correctness, completeness of his Can 2. On number 4, the placement of any individual on the primary or general election ballot may be challenged if this individual has not complied with the requirements set forth for candidates under Indiana law. As I go into further testimony, this particular statement, number 4, is supported by the exhibits that you are provided in giving you copies of the Indiana law, statute, verse, page, and document that supports what this requirement is. On number 6, the declaration of candidacy for primary nomination in 2026 lists as candidate certification highlighted in a standalone outline block, lists 7 through 13 specific questions that each candidate must initial and sign under oath. When these questions are not completed, the candidate has failed to complete their form and declaration. If they are answered untruthfully, this is a violation of the sworn statement. Specific evidence will be presented here, and I believe was admitted in part that Mr. Hobbs had not provided all required filed records, documents, etc. from prior candidacies. Number 7 states, if the candidate certifies as I have filed all reports required by IC 39510 for all previous candidates. 7A, the candidate indicate that these reports had been filed when the records confirmed that these required reports had not. There is a significant discrepancy in the CFA-4s and related schedules identifying a substantial shortage of reported expenditures by the committee. No CFA-1 amendment was filed for 2025, nor was a prior CFA-4 filed closing out the prior committee finances. The CFA-1 indicates the CFA-4 is for the Office of County Commissioner. Statute requires that this document to have been amended and that a yearly financial report be filed for the entire year. This candidate only files their CFA-4 for 6 months. The filing and records between the 2024 primary election through July 2025 were not filed with the county. This action confirms the candidacy falsely stated in number 12 that said records were filed when they were not. As an addendum to this, as I will provide in detailed testimony, after a comprehensive audit, significant numbers of documents were not filed. So by my testimony, this may help you move forward, as your counselor had suggested that you will be making modifications to improve how you can work with the candidacies and to allow a better understanding as to what these documents are required to be. On number 9, a CAN 2 may not be amended. Thus, not completing the form or failing to answer all questions complete and true is the same as not completing filing requirements. And then number 11, the candidate has amended prior filings, yet the amendments do not align with their prior current documents. If you were in office in 2025 and you had closed out your prior committee financial reports, you were required to file a new CFA-1 in July of 2025. Delinquent and defective records are subject to enforcement and penalties by the election division. However, a CAN 2 serves as your notice and sworn statement that you don't have delinquent forms. And I mentioned that in my opening statement. As I move forward, I'd like to take just a break and get a drink, please. In the packet you have before you, I ask that you turn to the first page, the color page that was submitted. This is not the same document that was sent out by the clerk. My documents have color highlighting on them, and we will walk through these documents. I do acknowledge that as you review this, if you do need additional help in sorting out the audit that I did, because unless you follow through this step by step, it is confusing. On January 20th, 2026, Sam Hobbs filed a CAN 2 in which he swore that I certify that the information in the declaration of candidacy is true and complete. 12 states that I have filed all reports required by IC 39-510 for all previous candidacies. He marked this yes. This is a false statement. He also initialed number 10. By initialing, I acknowledge that I am aware of the provisions of the Indiana Campaign Finance Act. IC 39. Regarding campaign finance and the reporting of campaign finance contributions and expenses. And I agree to comply with IC 39. Excuse me, I do have a medical condition that causes me to lose my voice. Although Mr. Hobbs stated in his testimony that he has made some amendments and is in the process of filing those, your attorney did confirm that those may be signed in front of a notary public or the clerk's office. There was an opportunity for those records to be presented today in defense of his testimony. They were not. So I am going to continue with the report and the audit that I have based upon the materials that I had as of yesterday. So far we have 2 false statements having been made on the CAN 2. On 1/20/26, the CFA amendment was filed. This amendment appointed Michelle Hobbs as treasurer. She did not sign Section D41. On the same date, a CFA 4 summary sheet was filed. I draw attention to number 11, pre-primary marked with dates of reporting from 7/1/25 to 12/31/25. In this report, line 13 reports $6,851.91 as cash on hand beginning of this period. The period beginning is July 1st, 2025. Line 15A states to use Schedule A. No Schedule A was included, although his CFA 4 indicated it was. Again, $6,851.91 is now entered as new receipts and new income.
Pam, may I respectfully interrupt you for a moment? No. I think you would agree that the Indiana statutes, and you have cited them, require the board to conduct audits on the campaign finance reports, both as to whether they are being timely filed and as to the contents of them. And you would recognize in that statute that that is a separate proceeding, okay? Your emphasis has been today that you believe that there is evidence. In fact, Mr. Hobbs has, to a certain degree, admitted that there are amendments he would make to his forms, and therefore there is some degree of inadequacy and incorrectness in what has already been filed. So in that sense, you have essentially established the substance of your particular challenge and all. The board's not in a position to go through a line-by-line analysis of the financial reports today. That will have to be a separate hearing and under a new notice and all.
Admitted, agreed, but my summary that I'm giving is a part of my testimony, not to provide you to do an audit at this point. I understand the scope of what you may or may not do at a different hearing. But this will quickly, you will understand the reasoning behind this. And it is a significant part of my CAN 2 challenge. So please.
No, I don't think so, because for the reasons that Mr. Lorenz has just identified, that's a separate proceeding.
Oh.
Would you agree, let me ask this question, and because I've listened to everything you've said carefully, and I've gone through your packet as quickly as I could, having received it just this morning, but that the essence of your challenge is based on the last sentence of your item 6 in your statement regarding Mr. Hobbs. When these questions are not completed, the candidate has failed to complete their form. If they answer untruthfully or erroneously, this is a violation of the sworn statement, and specific evidence will be provided, which is what you're talking about. But the essence of your challenge is that Mr. Hobbs' forms were not completed accurately, and therefore you challenge his candidacy.
No, sir. That is partially correct. As an adjunct to that, my challenge is not just that his forms were completed incorrectly or
lately,
not completely,
yeah.
But there were forms that were absolutely not completed at all, a multitude of these. And that I will refine
But
this.
the essence of your complaint is that he therefore answered untruthfully, and that's why you're challenging. That's the essence of your complaint, whether absent, past, present, accurate, inaccurate. The essence of your complaint is that he answered question, whatever it is,
2
12?
questions he answered untruthfully.
12, he answered untruthfully.
And
And
now it is-
that's the basis and essence of your complaint,
Yes,
as
sir.
we understand it.
Yes, sir. Now, as part of my testimony, it's my responsibility to prove my statement, and I will.
I think Mr. Hobbs has already stipulated that.
No, sir.
I
Mr.
can't use that term, but I believe Mr. Hobbs has already acknowledged that
Pam,
the
the
truth of
issue
that.
here is, one, partially of timing. We have a limited amount of time to do all these things by statute, and we're trying to move forward. I'm hoping that you will agree that your remarks with regard to the general nature of some of your challenges are applicable in other candidates' cases, and we can take what you've already said with regard to Mr. Hobbs and apply that to other candidates you challenge, okay?
Respectfully, sir, that's not correct, because in a hearing, each testimony is per each challenged
But you
individual.
can incorporate by reference what you have already said as to the general nature of the challenge to another challenger.
Yes, sir. May I have 10
You
minutes?
have already formed the origin of how you've presented it. You have made a single page, 2-page document with numbered paragraphs that you have selectively applied to each of the candidates.
Yes,
okay?
sir. Now I am giving you the testimony.
They
I will
are-
do this in 5 minutes. There's a reasonable amount of time to
You may
allow me
have
to.
5 more minutes, but we've
Okay.
got to get on.
Yes, sir. So as I summarize, without giving the detail of each document that's wrong, when a treasurer leaves office, a new report must be filed. In the documents, it transfers between Mrs. Hobbs being the treasurer and Mr. Hobbs being the treasurer. There is a significant discrepancy in the funds. Whether you account it to mathematics or you account it to those missing records that for almost 2 years have not been filed, a multitude of reports. There is between $8,312 missing to approximately $22,019.79 missing from reported campaign finance money. These reports also indicate the name of the committee. Advertisements are already being run with information in them that do not align with what the rules and regulations are. I have given you the reference in my exhibits. I present exhibit A, B, D, E, F, and G, and my emphasis is in paragraph G of exhibit H. My emphasis of penalties, which is for a person who knowingly files a fraudulent report, commits a level 6 felony and is subject to a $10,000 fine, 2.5 years imprisonment, or both. IC 314-113. Now, before you today, Mr. Hobbs admitted that he has made mistakes. He did not file reports, but it was confusing. I draw attention to the fact that everywhere on your documents, there are warnings given. There's warnings given at the bottom of what you signed that states, if this is not true and accurate information, these are the penalties that you may be subject to. It is recommended that you follow the manual, that you get legal counsel. For you to say it was confusing and I made a mistake and I didn't understand how to do this, that may be an explanation as to why it occurred, but it does not satisfy the responsibility of an elected official. Should be one who is representative of being careful, exact, to take the necessary measures to obtain information and to read what they're signing. I request that the CEB uphold the Can 1 challenge I filed. If the CEB does not uphold the Can 1 challenge, then by evidence of testimony and documents, although I was not allowed to present my full testimony, but I will provide a copy of this as to what I had present here, that by evidence of the testimony and documents I have provided in front of you, which is an exact list highlighted of each document that was filed, each mistake that was found, the discrepancies of the financial records, the missing monies, that Mr. Hobbs' campaign finance documents must be pursued by the CEB, and I ask for an independent audit to be conducted to exercise the full scope and power of this board to administer their scope of enforcement. which is, I believe, what you've already reflected is your intent going forward to address these and to make this going forward easier for all. So, thank you.
Thank you.
Let me just certify a couple of things here. What remedy are you asking of the board in this particular challenge?
There are two remedies. My first remedy was that this candidate was challenged and he not be allowed to appear
On the ballot?
On the
You want to
ballot.
disqualify?
Be disqualified under the specific statutory requirement that the Can 2 signed under oath states that
We did
these
that.
are truthful responses, that all documents have been filed, and that this person is familiar and agrees to follow the specific statute and guidelines for financial records and reporting. Now, you have a copy of the state statute that goes through line by line by line that confirms that. That is outcome one. If this board chooses not to uphold my Can 1 filing, then I have requested that a comprehensive audit be done that addresses these outstanding documents that for an extensive period of time were not filed. Under the statute that provides the CEB the authority to do defective and deficient audits, you also have within your scope the power to implement, recommend both civil penalty as well as criminal penalty and different forms of compensation and payment, because for you to go through and review this, it is the candidate's responsibility to do that. It's the candidate's responsibility to hire counsel or to hire an accountant to do their record keeping. It's not under the budget capabilities of the clerk or the CEB to do that. So at a very minimum, to recover compensation for the loss of your time and expenses, and knowing that this candidate recognizes now that these reports were not filed, this is not simple mistake. This is not an error. You're required in your checklist to make sure that you have complied with the laws. The laws say that you will file certain reports by certain dates. And this is not just a report for now, it's from this last 4-year period of time. This was not done. This candidate knew that this is not done. And even in the attempt to do last-minute amendments, it's evident that I do not believe it's possible by any amendment to correct the disparities between the different types of documents that have been filed over the time. Thank
So
you.
the remedies you seek, as I wrote them down, were 1, disqualification, or a comprehensive audit, or 3, the assessment of civil or possible criminal penalties.
Yes.
That's correct? Those are the 3 remedies that the challenge seeks. And that is in the province of this board. Part of that's a separate hearing. Certainly a comprehensive audit would be. Thank you.
Thank you.
I will say on our copies, we ran out of colored ink. And so you can see they're highlighted, but they're not in color.
That's okay.
We ran out.
Thank you.
Thank you. Okay, let me give.
Let's Sam have a rebuttal.
Oh, yeah,
Yes,
Sam.
we're gonna do this
I'm sorry.
rebuttal
I
first.
apologize.
Give me just a second to move here.
Richard, he does not need to be sworn in again, does he?
He doesn't have to be sworn again. No.
Okay.
He's already under oath.
All right. Okay, Sam, would you like to make a rebuttal to those
You know, no, it's fairly simple, Tony, and you stated this, and she stated it. Yeah, is there things that we overlook, things we don't understand on forms? Absolutely. It's a comprehensive thing. You know, it states there, you sign that because you understand what it means. You sign that because you understand what it means in your own heart, not in hers. I signed the forms, I filled out the forms to the best of my ability, to the best of my knowledge. I realized there was stuff missing. We went back, we spent the last few days, me and my wife, getting the forms ready. We have those. Are they absolutely accurate to 100%? I don't know without somebody going through them and saying, this is accurate, or you're missing this, we need this. We're not hiding anything. There's no money missing at all. So, you know, I leave it in the hands of the board. You guys are all fair, I understand you, and I appreciate your position, but,
Is there any reason that he cannot, on his way out, go to the voter registrar and swear
She's not here
and sign? Oh, she's not here today?
Her mother has to.
Oh, I'm sorry. Yeah.
We would have to recess for me to go downstairs.
Okay. Well, we are going to take a recess anyway, so we're going to recess for 5 minutes.
And Sam may be excused if he has other
Yeah.
I
obligations.
just have one question.
Yes, sir.
What we've turned in today or filed today or come back tomorrow, because tomorrow's the sentence, I don't know what sentence is the right word. You know, when we turn in what we've redone, right, wrong, inaccurate, what we're missing, is there going to be, and you may not be able to answer it, is there going to be a time where you can present to us and all the candidates that we still need this or that or that?
We will have a hearing tomorrow, a continuation of our hearing tomorrow,
Okay.
where we will make initial findings. There may be in those processes additional hearings that are
Sure.
requested or scheduled for instance, campaign finance issues, et cetera.
Sure.
But our hearing tomorrow will lay out our initial findings and
Okay.
then any follow-up information.
And we need
Is
to
that a
be-
correct statement?
And that's at 9 o'clock in the morning, correct?
Yes, sir.
And I have some paperwork that.
Okay, with that, is that the last
Yeah,
question you
I'm
have?
done, yeah.
Okay, with that, we're going to recess for 5 minutes.
Can I ask a question?
Yes,
Do we turn the mics off during the recesses?
yes,
And do I pause?
I believe so, yes. Okay, I'll restate it. Oh, I'm sorry. The meeting is not in session yet. We're going to wait one more moment for our clerk. Let's see, where did I put the one I just did? Yes. Yes.
Sorry.
I think you should have paused the,
No.
No, she didn't pause the recording, just the video, just the recordings. Okay,
Richard, turn your mic on, please.
yes, mine is on. Turn. We'll call the meeting back into session. The board, again, we had two requests for early presentations. One we just finished with Sam Hobbs. The second one was with Christy Risk because she has a conflicting meeting. And so we're going to go ahead and ask Christy. Let's see, wait a second. Is Mr. William Folk, do you want to take William Folk first?
It doesn't make any difference.
Okay.
Is he here?
Is Mr. Folk here?
You can do them both together if you want, it's the same issue.
No, we can't
Okay.
do it together.
We cannot. Is Mr. Newman here?
Yes.
Walter Newman. Okay. All right. Richard, in this particular case, it's the same process, correct? We're going to do the...
Well, let the challenger present her contentions in each case, please.
Okay. We'll go ahead and have Christy come up.
Any statement?
Christy, please raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be true, the whole truth, and nothing but the truth?
I do.
Could you state your full name for the record, please?
Christy Marie Risk,
And your position?
County Chair of the Republican Party.
Okay. Would you go ahead with your challenges, please?
So I get opening statement too, right?
Yes.
Okay. All right. Members of the board, council, I want to start by being very clear. I believe the public has an absolute right to transparency. My opening statement applies to all challenges of the Republican candidates. Our community and public have the right to question, to hold us accountable, and to demand that rules are followed. I welcome that. It's the heartbeat of a healthy democracy. However, there is a massive difference between accountability and harassment. I am concentrating and concerned that we are currently seeing a pattern where mistakes are being weaponized to disqualify candidates. I've spoken with the State Board of Elections, and their guidance is consistent. While mistakes can lead to fines, they shouldn't be a kill switch for candidacy. If we allow every mistake to become a disqualifying event, we won't have an election, we'll have a vacancy crisis. If we let these standalone rules be used as a trap to bully good people out of the race, we will soon have no one left willing to run for office. Our job is to protect the integrity of the ballot, not to assist in the systematic removal of those who step up to serve. So I am asking this board to prioritize the substance of the law over the pedantry of the challengers that are other than myself. My challenges are based on Indiana Code 3-8-1-5, which provides the primary reasons a person is disqualified from the ballot or from holding office as being felony convictions, party affiliation, the two-party primary rule, residency and voter registration, legal and professional conflicts. Regarding my challenge of William Folk has only voted in one primary, and he did not reach out to me as a county chair, or I would have addressed the current voting record with him. In short, the law allows the assurance that the people running as Republicans or Democrats are actually committed members of the party and treats political parties like private clubs. The state argues that a club should have the right to decide who represents it. Thank you.
Thank you. Thank you, Christy, and thank you for your opening statement.
And did she, while she's here and sworn, do you want to take her information the same, I presume, as to
Walter Newman? Walter Newman only has one vote in a general election, no primary votes at all.
Okay. And so both Mr. Newman and Mr. Folk, according to your challenge, did not meet the having voted in two previous primaries
Correct.
rule, correct?
Republican primaries.
Republican primaries, okay. Any other issues with that?
That's
Just
all.
those? Okay.
the challenger correctly recites the law that's involved here, and this was an amendment to make it two primaries at all. It's an interesting circumstance because as numbers of persons who don't vote in the primary decline, it becomes harder and harder to find the people who are eligible to be candidates. And also, it's a two-edged sword, but she's correctly recited, and the persons who did not appear are at their peril, that the decision can be made adverse to their decision.
And to add on to that, for the record, Ms. Risk did point out that neither one of those candidates, if I understood it correctly, came to you prior
Correct.
to the filing and asked for your permission to run as
Or
a-
just asked for help or
Or
information, or I
either
could have
way.
explained to them that.
Did not contact you either
Correct.
way? Okay.
Right.
All righty. And I believe Mr. Falk is not here, but Mr. Newman is here, is that correct?
I think they're both
Okay.
here.
Mr. Newman should be heard.
They're
then.
both here.
Okay.
Question
Yes.
again, Richard, would you, or Christie, could you give me that code again, because it's a little different from
Oh,
what I
it's
have in my
the
notes?
3185. I believe.
3185?
Yeah.
Okay.
Is that correct?
I'm looking at 3827.
I thought it was 3815.
Oh, did I transpose them, 3815?
It's in your materials.
Okay, gotcha.
Okay. I see 3827 here, but I don't know. Okay, thank you.
All right, thank you, Christie. All right, the chair will recognize Mr. Walter Newman, if you could come forward, please. Could you raise your right hand, sir? Do you swear or affirm under the penalties for perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, could you state your full name for the record, please?
Walter Lee Newman.
Okay. And Mr. Newman, could you state for us the office that you were seeking? while you came?
County Council District 1.
Okay. All right, please have a seat. Mr. Newman, you have before you the copies of the documents that you have filed with the clerk of the Owen Circuit Court for candidacy in the primary election. Would you review those documents and determine whether they're true and accurate copies of the forms that you filed?
Yes, sir. Well, the only ones I got was this one. That was the filing challenge.
Okay?
And then these. These are the Indiana,
Voter records?
yeah, that's the only thing I have gotten. I left the other at home. I did not know I needed that.
Okay.
Because it should have been attached with this. With all legal proceeding, it should have been attached with that.
When you say the other forms, you mean like your Can 2?
Can
Yes,
2 and Can 12?
yes, it should have
Okay.
been.
Do you have the copy of that? Oh, that's in this packet here, isn't it? Yeah. Let me get to the right one.
I don't think I have it.
Do we not have the walking?
This is the packet I originally
I
had.
did not receive that original set of documents
Oh,
for this
okay.
candidate, no.
Okay.
Right.
And they were not part of Pam Rogers' challenges, so they,
No, it's not filed.
so
You
it's
did
not,
file
okay.
the candidate 1, candidate 12,
Yes.
CFA 1.
Yeah, I believe so.
Okay.
And to the best of your knowledge, they were truly correct.
Yes, sir.
Submitted, no.
Okay.
This issue arises almost separately from that question anyway, because residency is an issue of disqualification immediately. Do you have a response as to the question about your voting?
Yes, one, the county clerk told me I had to choose. I was not choosing either parties.
Okay.
And that's, you cannot check other than Republican or Democrat on that there form.
Did you vote in the same county in all?
Yes.
Okay.
And here's my question, it comes down to, she's talking about good candidacy. Well, our forefathers gave us our constitutional rights. Why is state trying to be above that? They have no clue of constitutional rights. They're trying to take away constitutional
Okay,
rights
let me-
with that
let me-
amendment law.
Let me interject here. So this hearing is not about what the state has allowed or decided to allow regarding parties. They have their party rules, and that's already passed by the state. So that question would be more directed at the state.
Yeah.
What I'm trying to understand is, was your original intent to run as an independent?
Yes,
Okay, if you're running as an independent in the state of Indiana, there is no primary, because independents don't have a primary. Primaries are for parties, please, let me finish. Primaries are for parties to pick their candidates, the ones that they want to pick for their ballot to run in the general election. So if a person's intent is to run for an independent, then you would not file an application for the primary.
But that was not explained.
Okay.
So therefore, it's not my mistake.
Well,
It should be clearly marked on the paper.
okay, so the issue at hand is whether or not you are having a candidacy for the Republican Party in this case, because you checked Republican on the
I
box,
had no
correct?
choice. He told me to pick one.
Okay, so in that case then, we don't give our findings till tomorrow, but I don't think any more evidence needs to be heard at this point, because the intent, your original intent was to file as an independent, and you do not have a voting record according to
Jesse has a record of it besides this, because I have voted.
Well, yeah, but
And in the last couple of elections, I could not vote
Right,
due to COVID.
okay.
What
So
is the guideline for COVID? You couldn't go out. You had to be isolated.
the way the rule reads is that the last two primary elections, and that's what.
Then that
she's
rule
basing her
should
challenge
be changed.
But
It
it-
should be strictened
on.
from the rules.
Regardless, Mr. Newman, we'll issue our findings tomorrow, but regardless, it doesn't prevent a person from running as an independent on the general ballot, even if the finding is that you did not qualify for a party ballot for the primary.
You know, that's fine, because civil lawsuit could deal with this issue.
Yes, those are,
Let me explain. You have the right to appeal from this decision by the board. And I hear your comments because there have been complaints made at the state court level as to whether or not the statute as amended is constitutional. The appellate courts have declined any kind of ability to rescind what the state legislature has done at the point in time. And of course, the local board has no authority to change the state statute. So we're obligated to follow what the state law is at the present time. But your complaints are understood, and you're free to file whatever appropriate remedies you seek.
Yep.
yes.
Okay?
Thank you so much for your time. All righty.
Thank you for coming in.
Thank you. And Mr. Falk is not present, and so the board will take that into consideration when we make our determinations.
Ms. Risk should still comment.
Do you want any rebuttal or comments? Okay, Christie?
And she should
Okay.
also comment on Mr. Falk.
On Mr. Falk or Mr. Newman? One of you
Well,
said.
she's entitled to rebuttal on
Right.
Mr.
Newman.
Newman, and she issued the challenge on Mr. Falk, so she should
Yes.
speak to that. I assume she'll say ditto.
Well, and you did state in your initial challenge that it was the same issue for both candidates, correct?
Correct. Mr.
Okay.
Folk had no voting record, Mr. Newman had one.
Okay, and could you go ahead with your rebuttal on Mr. Newman?
So this is a party rule, and what I wanted to say was, we want people to run for office and we want people to be involved. So this is nothing against, this is not a personal thing, this is just strictly a law that's established. And so I would welcome any of those people that have filed that are being challenged to come, participate in the activities and get to know us, and I would love to have them. If they had had two-party challenge or votes, I wouldn't have even challenged it, I wouldn't have thought anything of it, so I just want to make that clear.
Very good, thank you. Do you have any comments, further comments on Mr.
I
Falk?
do have one. The election deputy cannot tell the candidate what to put on their paper. We cannot answer those questions for them.
And Linda's not here today, but we assume in this situation, she did not tell them.
She did not tell them,
Okay.
she cannot tell them what to put on that paper.
No, but the candidate could ask, so if they said, I want to run independent, then she would have said, okay, then you don't need it. She would have explained, yes.
That you can only do Democrat,
Right.
Republican.
Right.
Yes.
Yep, because
Okay.
anybody's welcome to run in the general election. Yeah.
Sure, right.
Okay.
Okay.
Do that, I think.
Yes, yeah, that's what I explained to him. Thank you, Christie. I explained to Mr. Newman that it does not prevent him from running in the general election as an independent. So, regardless of what our finding was, so. All righty, thank you so much, appreciate it.
Point of order question.
Yes,
I need clarification, please. In the first challenge, you had the challenge go before the challenger, Now you have reversed that.
It was because of the issues. This challenge was stated by the county chairman for that particular party.
So are we going then back to the challenge, speaking first before the challenger, or?
We're going to, yes, for all of the other challenges that you presented, we will still go with the challenged, the candidate, or the person who filed for the candidacy. We will get their sworn statement, ask if there's any corrections, et cetera, omissions, and then we will have you come up for the challenge. Yes.
In your challenges, we want to make sure that we have the record of their official candidate 2, 12, and the 1. We want to make sure that's a record first.
Thank you for clarification.
The other two were not due to an error on the form or something that they omitted. It was just their eligibility to
Thank you
even.
for clarification.
Yeah. Okay. We will take the next ones in order. Mr. White? Dusty White?
May I ask a question?
Yes.
Instead of, in order to conserve time, if I may suggest those that will be very quick.
Go for it.
My first suggestion would be Sandra Calvert challenge.
Okay.
And just as a matter of respect of time, I thought I could make it.
How many do you have in that you think will be,
The shorter version?
yeah, shorter versions?
Lori Wagner, Sandy Calvert, and then I believe,
Lori Warner, did you mean?
yes, I think Sandy and then Lori would be the next two quickest ones.
Okay. Do any of you have any issues with that?
I do not.
Okay, we will go ahead with that. That's fine, thank you. We will go to Sandra Calvert. If Sandra could come forward, and you did sign in, correct, Sandy? Okay.
Thank you.
Okay. Sandy, would you raise your right hand, please? Do you swear or affirm under the penalties of perjury that testimony you're about to give will be true, the whole truth, and nothing but the truth?
Yes.
Okay, could you state your full name for the record, please?
Sandra K. Calvert.
Okay. Sandy, you have before you the copies of the documents that you have filed with the clerk of the Owen Circuit Court for candidacy in the primary election. Would you review those documents and determine whether they are true and accurate copies of the forms that you filed?
They are.
Okay. For the record, the witness has authenticated and stipulated to the Can 2, Can 12, and CF1 as those are displayed in the respective packet, and those are made apart from this record, or a part of this record, rather. Okay. One moment while I get to your page. Do you know what depth that is? Oh, thank you so much. Okay. All right, Ms. Calvert, is there, excuse me. Are there any errors or omissions rather, on those forms that you would wish to discuss at this point?
Well, in looking at them again, it's been highlighted that I left out my precinct, which is Montgomery Precinct in Montgomery Township, and that I failed to include my candidate name information, which this is not the easiest part of the form to understand because there's no line to write on.
You're talking about your Can 2, right?
Yes,
Okay, thank you.
I think that was the only two omissions that I made on the documents.
Okay. Hang on just a moment.
intent was to have my name exactly the way it was on the form, so.
Okay. Do you wish to clarify or expand on the reasons for those errors, omissions?
Just an oversight on my part.
Just an oversight, okay? You understand that the challenger has identified a number of discrepancies and deficiencies that she has observed in your documentation, which
Yes.
we've just briefly covered, that the candidate did not sign under oath and failure to complete candidate name info. However, the signature by the clerk is, and the clerk stamp is included on the Can 2, I'm sorry, and therefore, I think the first challenge is moot, because it is signed where it says subscribed and sworn to me before this 21st day of January,
Yes.
2026. Yes.
Linda put my stamp on this.
Okay, very
I
good.
signed in front of Linda.
All right, and then the other issue was the failure to complete candidate name information and township, which you listed already on there, in your statement, okay. And did you, Sandra, read the statement that says, "I certify the information in this declaration of candidacy is true and complete, and that I meet the specific requirements of this office"?
Yes.
Okay? And the deputy clerk was available at the time that you turned in the form, and they did sign in your presence, correct? Okay? All right. Then there's a third challenge. It says no signature of clerk on the Can 12 form. You got it? Okay. There is the stamp. Was it signed elsewhere on the form?
She stamped it on the front, she did not put my stamp on the back.
Okay, so the seal was on there, affixed, but not the signature. Okay,
She's got
so that
it on
was
the
just
front
a
page,
minute.
she did not put a stamp on the second page.
Gotcha. Okay, but the signature does appear on the first page, under the filed. Or am I incorrect on that?
No, you're correct. That's
Okay,
correct.
okay. All right. Would you like to make any further statements, Sandy, on that before we have the challenger come up?
No.
Okay?
One more
So-
thing, Sandy, if you had filled in the information for the name, what would you have put in those blanks?
Just Sandra Calvert.
Okay. Since you had a former name, I was just concerned that you were using the same name for the balloting purpose of,
No.
yes,
Yeah,
okay.
Sandra Calvert's what I would have used.
Okay.
So your position is, in short, that these were clerical errors on your part, just omissions where you missed the blank?
Correct.
Okay.
Thank you.
Just a minute. I don't know why. I need to take the staple out of these. Do you have the individual packets that he's?
I broke mine out.
Oh, those are the
Gave
ones,
it to me,
okay,
yeah.
gotcha. Yeah, that's what I should have done, because these are. they're
I knew
difficult
I'd
to
get
read
lost.
through. Yeah. Okay, with that, Sandy, I appreciate it.
One more thing I just thought of.
Oh.
Sandy, you presented all the forms at the same time?
Yes.
Thank you.
Okay, thank you. I'm not seeing that Can 12 for her. Got the Can 2.
Here it is, Can 12.
For her, okay. And your file and the signature.
Signature's
So
there.
it was just that it wasn't in the right location,
She did not put my stamp here, but she put it.
but
on
she
here.
did here
On
with
the
the
front
signature.
page.
On the front page, okay. All righty, thank you, Sandy.
Thank you.
Pam, would you like to come up, please? And you're already sworn in, so we don't have to go through that process again.
Thank you, thank you. Before I begin, I have a statement. I have an objection to file regarding the testimony and statement to be accepted by Christy Risk during the prior testimony. Christy Risk made a statement under testimony regarding challenges filed against others, not challenged by herself. Testimony is not permitted for consideration by the public in a challenge, and those statements made by Christy Risk were beyond the scope of her challenge, and they should be stricken. So I may not make any comment, nor the public, on a challenge issued by others. So although I appreciate the intent and content of her statement, I'm requesting that any reference to challenges made against other candidates be stricken because it's beyond the scope of her statement for her challenge.
Duly noted. I don't know, that's something that we will consider.
Just as long as it's on record.
Yeah.
So before you, you have the packet that I am submitting for my testimony evidence that I filed regarding Sandra Calvert. I'd like to begin with the act of submitting the Can-2 for filing does not fulfill the definition or requirement that a declaration of candidacy for primary nomination in the 2026 Can-2 satisfies the requirement unless the form's information is true and complete. Throughout this document and what is provided to you in the exhibits, the law requires true and complete of the Can-12, or of the Can-2. Regarding number 2, the CEB just made a statement that the first challenge was mute. I would like to draw your attention to your misinterpretation of what was stated. Per number 2, page 15 of 2026 of the Indiana Candidate Guide states, the candidacy document needs to be completed, and I emphasize completed, and if applicable, notarized, since a notary cannot notarize a signature unless the individual is present and signs the document before. So the Can-2 was signed correctly, however, the Can-2 is not complete. So my challenge statement should stand as presented. Number 16 states that a candidate must emphasize, and I list emphasize, the individual's name on the candidate's filing in the same form as the individual wants the name to appear on the ballot, and the candidate's name is permitted to appear on the ballot under IC 357. Furthermore, it states that by filing the candidacy document, the candidate consents for their name on their voter registration record to be matched to their ballot name, IC 3576. Per the emphasis found on the bottom of page 1 of the Can-2, if a candidate's name does not comply with IC 357, the declaration may be challenged under IC 3812. So not only does this form draw attention to the candidate of the importance of completing the form, the statute, as well as each manual that oversees both the administration of and the candidacy's filing emphasizes the specific requirements of this. The placement of an individual on a general primary election ballot may be challenged if the individual has not complied with the requirements set forth. And a Can-2 may not be amended. Thus, not completing the form and failing to answer all answers is not the same as completing filing requirements. Now, I'd like to move on to a very brief statement, but before I begin, I would like to address the signature statement on the Can-12, which you have in front of you. I respectfully challenge the board when they state that the front page was signed on the Can-12. The filing stamp is not a signature. The purpose of the signature by the clerk on the Can-12 is that if you read the fine print, this is a sworn statement. So as a part of the CAN 12, the clerk or a notary, in whichever that person chooses to use, is attesting to the applicant, the candidate, as making a sworn statement. If there is no signature, there is no evidence that the CAN 12 was submitted under the legal requirements that's very clearly identified in the exhibits that I will refer to in just a moment. So the CAN 12 is of no effect. An unsigned CAN 12, even though I can admit that this very well was not intentional, and it was a clerical error. For whatever reason the error occurred, part of the obligation as a candidate when you leave that office is that you check your paperwork. When you come in and you file, you are required to be responsible for what you are given. If you find an error, you're required to engage that clerk at that time. This is all written out in your manual. These are the rules you're supposed to follow. Too many times we are discharging, oh my goodness, I didn't know where the line was, onto the duties of that clerk's office when it's not the duty of that clerk office to make sure that these are all being processed correctly. A missed signature, I cannot attest, nor could anyone, to state, was that given under a sworn testimony? By law, without that signature, it is not. Just because it's file stamped does not, when you walk into that office, they hit a button with a time stamp, or they file stamp it. The last thing that occurs is that signature on that line. So I am not able to say whether it was a mistake or not, or to decide if that should be accepted or not. That is before this board to make that decision. So going on, Sandra Calvert filed the CAN 2 on 1/24/26. She failed to answer number 1, identify the precinct, and failed to answer what county as mandatory, facts supported in Exhibit A. She also failed to designate candidate name information. IC 3827 requires that the candidate must specify by designation each designation that the candidate wants to use that is permitted. This is not an option but a requirement. A blank section under the candidate's name invalidates the CAN 2 filing, as no voter card could be changed to read blank, no name. That is clearly identified in the statute, that how you fill out that section to designate your name to appear on the ballot also triggers the clerk's office to amend your voter's registration card. In this instance, there's no name, it's blank. I admit that it absolutely had to have been a mistake. It was not intentional. There was no intent by this. It was a mistake, but unfortunately, it's a mistake that might invalidate the ability for this CAN 2 to be accepted. Sandra appears to have correctly and timely filed all prior records and documents, and my kudos to her for how efficient and correct her other paperwork was. Exhibit D, page 7, contains the wording that provides that each candidate regarding the 2026 Indiana Candidate Guide requirements for this challenge, that a candidate must list the individual's name in the same form as the individual wants the name to appear on the ballot. To implement this requirement, a candidate's designation is fully identified. So in your Exhibit D, page 7, addresses that, and Exhibit F provides further. Corrections and amendment to CAN 2 is not permitted by law. A new CAN 2 could have been filed up until the deadline to facilitate a correction, and I request that my challenge be upheld with no civil or any penalty issued. I earnestly believe that this is a very good person that made just a simple mistake, but it's to be fair in all of my challenges. I'm not the one judging as to whether I think it was a mistake or not. I filed challenges equally and without bias. This is one of those.
If I may ask a couple questions.
Yes, sir.
Pam, I believe you understand and recognize that the Can 2 bears Sandra's signature as well as that of the clerk and all, right?
Yes.
Okay, and that document was, again, also certified under oath because of the pre-printed language of
Yes,
the
that is
form and all.
correct.
In candidate 12, you're missing the signature block for the clerk and all, although you do have the clerk's stamp on the same line and a block filled out by the clerk, and you have on the preceding page the final mark stamp containing the signature of the clerk and all that was done on the same day, which would infer, would it not, that the clerk's office did in fact see and observe the candidate at the same time?
Sir, in response to that, whether they see the candidate at the same time is not the question. It is whether or not that person submitted this document under a sworn statement and there's no signature.
The oath is on the Form 12, pre-printed and all above the signature of Sandra, right? It's there, it's on the top of page 2 of that form.
That is correct.
Okay. I'm just trying to make some observations, okay?
That
All
is
right,
correct.
That's all I have.
Yeah.
So to summarize then, if I may, your contention is that the form is filled out incorrectly and thus the signature is invalid because she's signing to facts,
sir.
not in evidence.
No, sir, that's not what I
And that you
stated.
don't, please? And as regards the file stamp on the Can 12, you don't regard that to be adequate signature. Am I understanding that correct?
No, sir. Regarding your first statement, I'm unclear about what you meant regarding that her signature isn't valid on the Can 2.
Well, you
Sandra's signature is valid.
said that your challenge is based on the fact that the form is not true and complete.
That is
And then-
correct.
And then you cite the code regarding the signature.
Okay, I cite the code regarding the completeness and that her signature is accurate. I don't challenge her signature at all. I challenge whether or not the Can 2 can be accepted because
Because
it
it's
is
incomplete.
not
Okay, not true and
and
complete.
complete. No
I
challenge
stand
against-
corrected. You're not
yeah,
talking
no
about the
challenge against
signature. You're just
signature.
saying the form is not complete and therefore invalid in your opinion.
That is-
And on the Can 12, that the clerk's stamp on the reverse of the form does not qualify as a signature, in your opinion.
Those are correct.
Okay, thank you.
Yes,
And
sir.
you, the remedy you seek is none. Is that what I'm understanding?
The remedy I seek is for the CEB to review statute and law specific regarding this and to make an appropriate finding of fact as to whether or not a Can 2 is complete and can be accepted when there's no designation of name on that candidacy form.
Okay, we
And
understand.
whether the invalid Can 12 then
We understand. Okay, thank you.
that the Can 12 neutralizes the Can 2 because it was not signed. Thank you.
Thank you.
Just making a note here.
Yeah. Sandy gets a rebuttal if she wants it.
Yes. Sandy, would you like to come up and give a rebuttal?
Or does she have any rebuttal? She may not.
have one?
Or do you have any? Okay. Okay. All right, having none from Sandy Calvert, we will move on to Lori Warner. Lori, if you could come forward, please. Lori, do you swear or affirm under the penalty of perjury that testimony you're about to give will be true, the whole truth, and nothing but the truth? Could you state your whole name for the record, please?
Lori Lee Warner.
Okay, thank you. Please have a seat.
If I may, before we get started, the candidate filing challenge CAN 1 that I received with my packet identifies the person as Lori L. Wagner.
Okay,
I am not Lori L. Wagner, I am Lori L. Warner.
okay,
So this is incomplete and not correct.
okay. Very good, good point, duly noted. So, I have a legal question here, Mr. Attorney. Under the duties of the CEB Board, if a CAN 1 form is incomplete and not signed or sworn to, then...
In this particular case, that is not the objection. The objection is that the questions 7 through 13 were not filled out and complete.
Correct, but the challenge was made made with the incorrect name. So instead of Lori Warner, it's Lori Wagner.
We will talk about that further when the challenger is presenting.
Okay, very good. All righty. So duly noted, Lori, thank you. Okay, you have before you the copies of the documents that you have filed with the clerk of Owen Circuit Court for candidacy in the primary election. Would you review those documents and determine whether they are true and accurate copies of what you filed?
My copies are the ones that was handed right here to me.
Okay,
Which one? I mean, yes, the answer is yes.
okay, very good. For the record, the witness has authenticated and stipulated to the CAN 2, CAN 12, and CF 1 as those are displayed in the respective packet. Are there any errors or omissions on those forms?
Yes, sir.
Okay. Do you wish to clarify or expand on the reasons for those errors or omissions?
Yes, sir.
Okay.
So in my excitement of filing, and I did not sign until I got there, and I made a point to that, but in my excitement, I did fail to answer 7 through 13. Most of my form I had done at home on the computer because I wanted it to be legible and correct. But in that excitement, on the candidate certification, I did fail to answer with my initials, and there was 2 yes/no questions.
Okay.
There is also, there's another one, there's another one where I failed a signature. I had, as I said before, I filled it out and typed it in, but due to my excitement of doing this, I failed to do that. It was an oversight. I was not trying to withhold information. I'm not trying to hide information.
I'm sorry, I lost you. Where are you talking about?
7 through 12.
I got
or 13.
7
Yeah.
through 13, but you're talking about something else, right?
On
I'd have to look the challenge here for a second, I'm
I
sure I'll
think
hear
she's
about it.
also referring to the CFA 1.
The CFA
which
1
does
at the
not
bottom,
contain signatures of the chairperson or the treasurer.
yes, I
In the
failed to do
appropriate
that,
locations.
so.
Gotcha. And so your stated reason, obviously, was the excitement of doing it, but that it was not intentional?
It was
if I
not
understood you
intentional.
correct, and that you were not trying to hide anything?
I was
It
not.
was just an oversight?
Yes,
Is
sir.
that what your statement was?
Yes.
Okay. All righty.
And the CFA 1 can be amended.
And I will do that.
And just for the record, again, CFA challenges are separate than the actual CAN 2 challenges. They require a separate hearing.
That is true for campaign financing reports.
Okay.
The CFA 1 filed initially with the candidate filing of declaration is a bit of a different animal, okay? And it deserves additional consideration because the failure to sign documents, even though they are forms, is a legal requirement and all. They are authenticating certain information that is a part of the process and all. And it will require deliberation on the part of the board to determine if a form that is unsigned is essentially a non-submission. Okay?
Okay. But the law does state that the CFA 1 can be amended?
Be amended.
Okay. Does an amendment mean that the form has to be filled out in the first place and just incorrect, or just,
This will be a case of the first instance, was it filled out?
okay,
That's in this particular circumstance, yes.
okay, okay, all righty. And your reason again on the CFA form, was that the same as the reason on the?
I followed
other
them all
form?
together.
Okay, okay.
And I knew that I should wait to sign when I got there. And I just had missed that. I was trying to get it done, and Linda was stamping and all that. And, yeah, we need training on this. I'm a first-time candidate like this, so.
Okay. All
But
right.
it was nothing intentional, no ill will.
Okay. All right. The other issue on the campaign, the CFA 1, is that you appear to be a treasurer on 2 committees. Is that an accurate statement?
That is an accurate statement.
Okay. And the way I understand the law, it only allows you to be a treasurer on 1
It
committee.
will be
at a
one of the
time.
considerations of the board.
Okay.
Okay.
Thank you.
I did not know that. Again, this is the first time that I had filed to run in something like this, so that I was not aware of that.
Okay.
I have to point out the irony that if she has not signed this form, she isn't a treasurer to more than one.
Right. And the way I understand it, the CAN 2 has to be filed with the CAN 12, but the same requirement is not. as
That will be
strict
one of the
on this.
findings required by the board.
There you go, very good, okay, thank you. Okay. Any additional comments? All right.
My wish from this would be that I still will get to be on the ballot and that I can make amendment to this form. And I'd even be willing to help in future training so that y'all don't have to spend your day doing this again in future primaries.
Okay, all righty. You have any other questions, sir?
No, other than to point out, I think it is the individual's responsibility to do that, and/or their party. I don't think it's the election board's responsibility to
No,
conduct training.
No,
or
that's not what I
necessarily
meant.
be
I
the police on
meant
this.
in training for.
Yeah, no, the
within our
information
party.
needs to be gotten out there. I don't think we have the time or budget to train all this, do we?
Right.
No, yeah, absolutely not, so.
And legally cannot, okay. But it is a duly noted point, and I think we covered that in our opening statement by the attorney, that there are systemic issues that we need to address. Okay. Okay with that, then if you would go back to your seat, then we'll have Ms. Pam Rogers come up.
Thank you all.
Thank you.
Oh, timeout. Not a big loss. Thank you. My name is Pam Rogers. This is regarding Lori Warner's challenge. I'd like to start with the statement that I admit to a Scrivener error in the spelling of Lori Warner by using Wagner. Under a letter to confer, I requested to the county election board by council for leave to file an amendment, which is permitted by statute in the matter of a Scrivener error. My request was denied. That is a matter of record in the communications, and a letter of confer is appropriate when I, acting pro se in this matter, find a Scrivener error. So I did facilitate the necessary steps timely to enact a amendment, and that was denied. So I'd just like to have that on record.
Okay.
Regarding the first statement, and although I'm repeating these over and over because each person is of a separate hearing itself, I do ask that you consider, if I give you an abbreviated statement, that we accept what I have in writing to confer that, because I am losing my voice.
Officially, the board accepts and incorporates by reference the itemized paragraphs that you refer to.
Yes.
Automatically as part of a challenge in each of the candidates' portfolios.
Thank you, but since they're not in record, because there's some clarification as to how they're read, that I'm going through and hitting those highlights.
Well, we also accept by incorporation your general statement this
Yeah,
morning.
I think if you could abbreviate this.
I
very
will
much.
try, thank you. Again, I circle number 1, that the candidate, and I'll give you the abbreviated form, swearing to affirming the truth of the statements made, and that the document, under number 2, that the document needs to be completed and if applicable, notarized, since a notary can't sign or notarize a signature unless the individual is present. So throughout my incorporation, my emphasis is that it is a true and complete document. The can too, as you've heard throughout already, when a vast number of those questions are not answered, that is not a true and complete document. And it provides that candidate an opportunity to not be held accountable or not to admit that they are required to follow campaign finance rules and to file reports. There's no amendments that can be done to a Can 2. So the emphasis that is placed in bold on the Can 2 should direct the candidate to read what they're signing. There's no excuse for not reading what you sign. Placement on an individual in a primary general election can be challenged if they do not complete the requirements set forth under Indiana law, which is what is transpiring. Number 6, standalone, highlighted in blocks 7 through 13 questions. Each candidate must initial and sign under oath. When these questions are not completed, the candidate fails to complete their form of declarations. If they answer untruthfully, it is a violation of the sworn statement. And a failure to list complete responses such as precinct, county, specifics of the office seeking, all required information on the declaration. I also marked number 9, that the Can 2 may not be amended. So although there's a reference to amending the CFA 1, the Can 2 may not be amended. It stands on its own accord, and it is required to be true and complete. And number 10, I do admit that CFA 1s may be amended, and that is part of the purpose of my challenge, is to give the opportunity to others and to this board to recognize the vast amount of errors that are appearing on these forms that need to be addressed. So Lori filed her Can 2 on 1/23/2026. She failed to answer any questions 7 through 13. Furthermore, on page 2, Exhibit 8, it further identifies that the candidate must separately initial each of the statements required by this subdivision. Now I want to draw attention, this is state statute that you have in front of you. So it's not a matter of you just have to read this form and know how to fill it out. You have a manual that you are given access to. Within that manual, it refers to each requirement. The law, Indiana code says each question must be initialed, not may or should. So I emphasize that you read that statute in its entirety, which I have included. The CFA 1 is required to be filed. It was done on January 23rd. It's required to be under a signature of ink. So as a point was made, if there's not a signature, then that actually isn't a valid statement or document. That also means that the CFA wasn't filed. So that also means that the document is of no effect and it's invalid. She failed to answer 21, and she failed to sign as a chairperson. Do I need to?
No, I'm fine.
Okay, I'm sorry. Lori is also filed as treasurer by Norm Warner, and a great comment was made, so if she didn't sign this, maybe she's not the treasurer. At least this is an opportunity to sort this out. The fact needs further clarification due to the multiple amendments made by Norman Warner with conflicting information, which will become evident during that portion of the hearing. I submit exhibits D, E, F, G, H, I, J, as well as previously referenced exhibits A, B, C in support of my Can 1. I request you uphold my challenge that she not be allowed to be on the primary ballot. My emphasis on this is that there is no correction and no amendment that can be done to not filing a true and complete Can 2. Within the wisdom of this board, if a Scrivener error is made, as clearly, as careful as I am, I misspelled her name. Mistakes happen, and I admit that. There's a process that you follow when you make a mistake. I took that process. I should have been allowed to file an amendment. I wasn't. But that is for this board to take into consideration regarding whether or not to accept her challenge, to even accept the Can 1 because of the misspelling of her name, or to reference the effort that I made to file an amendment and was denied. So errors are possible by everyone, but the legality of a Can 2 requires by law that it be complete. And Ms. Warner, I believe, as you go through and you review the highlighted items within her documentation, she did forget her zip code on line 5. To me, that's a minor error, but not filling out 1 through 13 is something that eliminates the eligibility of this candidate from this Can 2 being accepted as a true declaration of candidacy.
For clarification purposes,
Yes.
you are not alleging that she did not sign the Can 2, just that questions 7 through 13 were left blank.
That is correct.
Okay.
Can you please, where are you saying that I am stating that she doesn't sign? Are you only reading a portion?
No, I'm just clarifying, because I want to make sure that you're saying that the candidate did not answer questions 7 through 13, but you're not making the allegation that she did not sign the Can 2.
That is correct. Her document is appropriately notarized, stamped. She did sign it. However, the document is of no effect because 7 through 13 is not answered, and it states, I certify the information in the Declaration of Canada is true and complete. Complete, the Black's Law definition of complete is one that
I think the board is pretty
Okay.
familiar with the
Yep.
word complete.
Right.
Tim, I've got a couple questions for you.
Yes, sir.
It is noted that the form does not have the candidate certifications in 7 through 13. Some of those items are merely recitals of the fact that they understand that they're obligated to file appropriate reports and they're under duties to carry out certain candidate requirements and all. And then right below that, in the same block that these are to be initialed, you have a signature by the individual, okay? Do you think that the board is not entitled to enforce every one of those provisions simply because they signed the form as to all those things immediately above in the same block?
If I may respond to that, thank you. That's why I gave you specific reference to the Indiana state statute that states what the law is. This is not a subjective matter that we get to decide as to what constitutes the completeness of this form. State law, they identify line by line
It
what
does
is
say those
required.
things you're supposed to do.
Let me
But the
finish, please.
initialization of a single item is merely a emphasis on that particular element of the matter.
Yes, sir, and by the statute as it's identified, without the initials, and they emphasize initials, without the initials, then that declaration, that candidate may not be upheld to those standards. And so they're not giving sworn statement that they agree to follow each of those things, and that they have provided a true and complete and correct document. So it's not for me to judge that. It's actually not for this board to judge that, I don't believe. It is, the state law goes through line by line of the CAN 2 to identify what is a must and shall response. Otherwise, no signature, no initial invalidates this from being a true and complete document. Thank you.
Okay. All right, Lori, would you like a rebuttal,
I
please?
sure would. Thank you, Tony.
Uh-huh.
So we have established what I had missed on the 7 through 12 or 13.
Uh-huh.
But back to the CAN 1, I like to read this here where Ms. Rogers on number 5 had put that she filing this, she questioning the eligibility of the following individual, Lori L. Wagner. She spelled that LoriLWagner. Down here in the challenger candidate certification, she had put and signed her name to, I swear or affirm that under the penalty for perjury, that the foregoing statements are true to the best of my knowledge and belief. Pamela Rogers. She signed this. Lori L. Wagner is not on the ballot. I have not, nor have I ever, or will I ever be Lori L. Wagner. So I don't believe that this can go forward with the mistakes that she had made. I mean, the whole reason we're here today is because we made errors, but I don't believe that I can falsely be accused when the person that is challenged on this CAN 1 is not me.
Thank you so much.
Thank you.
Any other statements?
Rebuttal.
Yes, you can have just a moment. Go ahead.
I did sign my CAN 1 under the statement that she read. And when I observed an unintentional Scrivener error, I proceeded with the lawful process to correct that Scrivener error, which was denied. That will be a matter for this board to determine, because admittedly, people do make mistakes, but admittedly,
They do.
admittedly, when people make mistakes, you follow due process to correct those mistakes when it is an unintentional error.
Okay,
Thank you.
thank you. Item 6.
And if the board may, I would like to do Nicholas next, please. for the next choice.
Okay with you?
I'm good with that.
Fine.
Are you?
Yeah.
Okay.
Yeah.
Hang on just a second, Nick. You go by Nick or Nicholas?
Nick is fine.
Okay. Nick, do you swear or affirm under the penalties of perjury that testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, would you please state your full name for the record?
Nicholas Daniel Pasenica.
Okay. Nick, you have before you the copies of the documents that you have filed with the clerk of the Owen Circuit Court for candidacy in the primary election. Would you review those documents and determine whether they are true and accurate copies of the forms that you filed?
They are.
Okay? Are there any errors or omissions on those forms?
Not to my knowledge, no.
Pardon me?
Not to my knowledge, no.
Okay. Do you wish to clarify or expand on any of the reasons for what her challenges are? In your statement, you're saying you don't believe there are any errors on them.
Not on my form. She's challenging my, I guess, residency.
Okay?
So I live here. My address is on my license. I've got brought documents for bills and tax forms. And I think there might be a challenge related to like finances. I've raised no money. I've spent no money. So there's nothing yet for me to file related to finances.
Okay? All righty. And Nick, did you read on page 2 of your Can-2 form that I certify that the information in this declaration of candidacy is true and complete and that I meet the specific requirements of this office?
Yes.
Okay? And was the clerk or deputy clerk available to take your form at the time of presentation?
Yes.
Okay. And let me get to the right page here. You got it pulled up already? Thank you. I see her challenge here, I don't see his forms. Unless it's behind the voting record, perhaps. There it is, sorry. Okay. Fantastic. Okay, residency challenge. Proponent says the address is vacant with no improvements and unpaid taxes. Do you have a response to this challenge?
All my taxes are paid.
Okay.
There is a house structure, tiny house on there. It's not on a permanent foundation, which is why it was recorded. When I did have somebody come out to try to assess it, they said...
I'm sorry, Nick, could you speak up?
Sorry.
I didn't hear that last sentence, I'm sorry.
It is listed as vacant because when I had somebody come out to assess it, they said it wasn't on a permanent foundation, so it would still be recorded the way that they record it. It's not that I don't live there, it's not that there's not a house there, it's that it's recorded that way specifically because it is not on a concrete foundation.
Okay. And how long have you maintained this residence at this address?
I've been there going on 9 years.
9 years, okay. And you just described the structure that's on the premises. And can you describe the dwelling use of this residence? It is a home?
Yes, I live there, I sleep there.
Okay.
It's my
Okay.
main residence.
Do you have a mailbox on the lot using
do.
that address? Okay. Do you have utility services?
I do.
Okay. And if so, what are those services?
Duke and Endeavor.
Okay. And you're saying, I think you made the statement when you first sat down that your driver's license shows this address as well?
It does.
Okay. Do you have a telephone service addressed to that location?
I do. I don't know what my phone number is, but you have to get a landline in order to have the internet, so
Okay.
I know that there's a number out there somewhere.
Okay. Did we see that you recently filed bankruptcy in the U.S. Bankruptcy Court? Terre Haute Division, and that you listed this address as your residence for jurisdictional purposes.
Correct.
Okay? I'm going to read this note from the county attorney. Indiana law requires many candidates, but not all, seeking state and local office to have resided in their election district for at least 1 year prior to the general election. Just as a matter of note, Nick has made a statement to this board that he's lived at this address for 9 years.
Going on 9 years, I think it's 8 officially, but yeah.
Okay, for a little bit over 8 years. Residency qualifications are detailed in IC 381, the Indiana State Constitution, and the specific office chapters of this guide. Residency means the place where a person has the person's true, fixed, permanent home and principal establishment, and to which place the person has, whenever absent, the intent of returning. IC 3552, a person's residency may be established by origin of birth or intent and conduct taken to implement the intent.
You don't need to read the rest of it. That was for the board's education.
Okay.
What the requirements were.
Okay, I didn't know if you wanted it public record or not. Okay.
There's also a continued question on 7 through 13 again.
Okay, and then the candidate did not answer questions 7 through 13 on Can 2. Would you like to expound on that or clarify that?
I have, it says I didn't answer the questions on Can 2. This is the Can 2. 7 through 13 are my initials next to every question.
This is Can 2. Quite the answer to me.
I don't have that.
Once again, when you look at the candidate 2 form, it does appear that those were answered and initialed appropriately, but it still is circled on the challenger statement.
Yes, and there is one missing on item number 12. There's no yes or no.
12 is supposed to be skipped.
I'm sorry, what was that?
It says on the form to skip 12 and proceed to 13.
Oh, I've got you. Okay,
He was not a prior candidate.
gotcha. Okay,
Yeah.
all righty. Okay. All right, so your contention is that all of those were signed appropriately, initialed, or checked, if they were appropriate?
Yes.
Okay. All right. Any other comments that you would like to add?
No.
Okay. Did you bring copies of those utility bills with you?
I have a picture of my Duke bill. I couldn't get my printer to work, but I do have other forms. I didn't make copies of them. I just didn't know if you needed to view them or if you needed me to submit them. I need to make, I've got a bill. I've got some tax documents that I would definitely need to keep.
Okay.
But if you want to view them, I can certainly give them to you.
Okay. Richard, did you?
It's not going to be necessary because the candidate has established a prima facie evidence of residency type thing. It's, the challenger has the burden of proof.
Gotcha. Okay. Very good. All righty. Thank you, Nick.
Thank you.
Pam, if you would like to come up.
Thank you again. Submit the package that was presented regarding this challenge and the exhibits for that. I include my previous statements made regarding the full scope and intent of a Can 2
Okay.
to be applied towards this challenge. Although 1 through 3 has been accepted, I would like to draw attention to what continues to be possibly a misinterpretation of the stated challenge reasons. On number 6, although I stated that they had not filled out number 7 through 13, number 6 reads, in the last sentence, when these questions are not completed, the candidate has failed to complete their form and declaration. If they answer untruthfully, this is a violation of the sworn statement. That is a part of what you only partially read. So in listing number 6, I do not challenge that he did not answer 7 through 13. I add the qualifier that if they're answered untruthfully, this is a violation of the sworn statement. This will be addressed as I referenced the CAN 12 statement and the evidence that I am presenting regarding this challenge. I do not need to reread all of the statements except for residency, and I emphasize, without reading everything I wrote, the person has a true, fixed, permanent home. Now, I believe I heard, and if I may use Nicholas, I have trouble pronouncing his last name, state that the assessor or someone came out and said because his home wasn't on a permanent foundation, that it wouldn't be assessed. Well, that in itself may support the statement that it's not a permanent, true, and fixed residence. And statute is different for what qualifies as residency for a person to vote, because you could be homeless and there are conditions that allow you to vote. The standards are different if you're running for office. And a matter of residency and the specific language as to what a true and fixed permanent home or structure is very relevant, not just for this challenge, but for obtaining a scope of understanding in our county as to what does qualify. Because a mailbox where you receive your mail does not qualify to allow you to run for a candidacy position. You can own a farm property and have no structure and no home on it. That does not qualify you to run. You have to have a true and fixed permanent residence in most of these standards.
Let me
As we
interject a question here.
Yes.
If what used to be called the Caseta Trailer Court, if a resident of one of those trailers that are, according to the assessor's site, they are listed as personal property, correct? Not an assessed home. If they live in one of those homes, by your allegation, they would not be eligible to run for office.
No, sir, that's not correct. Because the further definition of and again, I don't have the statute in front of me, but my interpretation and understanding, because I'm actually pretty well versed in this area, as to a mobile home. By code, a mobile home must be installed in a particular manner that does provide it a permanency in that location. It is also assessed by taxes. The challenge would be is if you're living in an RV. An RV does not fall under the qualifications of a true and fixed home. Okay. A mobile home does, but an RV does not. And if you can live in an RV for up to 6 months, I believe, by our statute and by our ordinance. After that, occupation is not permitted for residency purpose. In this particular challenge, I believe he stated that his structure was not on a permanent foundation. And I believe he also stated that he has paid his taxes. This will be addressed as I get deeper into this, because I have provided you with the records and receipts for that. So I'd like to start off by saying, in the statements in support of my CAN 1 filed, a summary of grounds were submitted in my testimony that I've given to you and our previous documents. Filing instructions alert the candidate to not wait until the deadline to file, stating that time is required to process each document, certify sworn documents, and to file your Can 2. Nicholas filed minutes before noon. His CFA 1 and Can 12 was file stamped. His Can 2 was not. There is no file stamp on his Can 2. Statute is very clear about what is required for a Can 2 to be accepted, and it draws attention to not waiting to the last minute and allowing proper time for the clerk to process what needs to be processed. Now, it's evident that the records were presented and that she had taken time to facilitate her steps, but in the last minutes before the deadline, the error or whatever occurred did prevent that file stamp from appearing on the Can 2. No file stamp is something that this board is going to have to further review to determine if this Can 2 can be accepted without the file stamp. And again, I emphasize that the extra time allowed is to allow all parties, the clerk and the candidate, to review each document for correctness before leaving the office. There's no excuse for waiting to the seconds before that causes this type of error to appear. So going on with the rest, residency requirements for a candidate are not the same as to vote. We've already discussed that. A person may own land or rent land in Owen County, but that does not satisfy the requirement of a true fixed permanent home. I have provided an exhibit packet and a copy of a property card printed by the assessor on 2/12/2026. The address is reported as vacant platted lot with no structures, and even a reduction given for no improvement cost to bring the parcel to the neighborhood land rates. I contacted the county health department. They have no record of septic improvements for this parcel. Now, that does not mean that there's not a septic there. It may mean that a septic was put in without a permit, or it was done in some manner that didn't facilitate our health department having a record of a septic for that particular vacant lot. Nicholas is the same name used by the candidate as his father, I assume. There are two Nicholases that are associated with this address. One in which the tax records are sent to. One which is the candidate who is listing this property as his residency. In a search for evidence, I provided a property profile report confirmed on 2/23/26 of a vacant lot, no structures, and 2 years of unpaid property taxes. That date is on the bottom of that receipt. So unless taxes were just paid yesterday, per the treasurer's office, those taxes still remain unpaid, and I believe it's at 2 years.
And this is for the last 2 years, correct?
That is correct.
Okay.
Court records confirm the address was used on January 30th, 2026 for a bankruptcy filing. On 1/23/26, a $20,000 plus judgment against Nicholas P. at this address for a credit card balance. On 10/4/25 for expired plates. Each of those legal documents does show this address that I admit to. That does not show that that is his residency. Maybe it does. This is for this board to address. Now, I do challenge on the Can 12 significant information that was left off.
Can I back you up for just 1 second, please?
Yes, sir.
On the, when you mentioned the two different people with the same name,
Yes, sir?
does any of that information apply to the other Nicholas?
Sir, this is one of the purposes behind the challenge, is that we have a Nicholas with an address of Crown Point, and we have a Nicholas with the address given in this Can 2.
Okay.
And it's beyond my scope to tell you which is whom. I can make an assumption that it is a relative, but when you review the other documents that I'll just go ahead and refer to right now, when you refer to the documents regarding a filing for the deed, so on a quitclaim deed, so I included copies of the deed, and we have a Nicholas with a Bloomington, Indiana address preparing the document. And on this same document, it indicates to mail the tax statements to 9731 Polk Street, Crown Point, Indiana. There's no middle initial used.
Okay.
So this is something that does need to be absolutely clarified.
Okay.
When you look at further reference, let me continue and then I'll go back to that, I'm sorry.
Okay.
You got me off track, I have to find
Sorry.
out where I am.
You started on the Can 12.
Okay. Regarding the Can 12, and specifically regarding my challenge of truthful statements,
Okay.
A Better Way Incorporated shows this address that he uses as a principal office address with Nicholas Daniel as the manager on 11/19/2025. That business association was not disclosed on his Can 12. The actual, it's non-certified, but is a copy of the filings made regarding this list Nicholas using the address in Poland, Indiana for the business called A Better Way Incorporated. And this information was not included on the Can 12. NADA LLC, created on 9/7/2025, lists Nicholas Daniel, not as a member as stated on the Can 12, but instead as a manager, along with 3 other members, all listing a business address at the address in Poland. His CFA 1 failed to answer number 20, which is required, and number 31. I went to the building department. I went to the assessor's office. At the building department, I asked to find any evidence of a building permit, certificate of occupancy, an exclusion or any permit that might be associated with this address. They looked back for a few years, none was found. That does not mean there isn't one in a record from way beyond, but our process is if a person obtains a building permit, that building permit, our departments, then transfers to the assessors that information. So at some point in time, that property would be assessed. Now, I challenge his statement that an assessor would come out and say, this building isn't on a permanent foundation, so it won't be assessed. I am assessed for a shed that sits on my property. I'm assessed for structures other than the home I live in. A farmer is assessed for outbuildings on their property, depending on the location and size, etc. So the correctness of that statement is one that I can't take at face value because I am more familiar with the processes at place. I also want to draw attention to, there's a requirement that makes it a felony. If you have property, if you make improvements on your property, over $500 in value. And regardless if the assessor gets to you within that 4-year cycle to assess your property, if you make those improvements, you get your tax bill and you see you're not paying for those improvements, you're required by law to go to the treasurer and the assessor and report those improvements. Now, when you look at an aerial view, you will see a shed, you'll see what appears to be a mobile home, you'll see lots of little structures. Facts do not align with this particular parcel, and facts do not support any evidence that this is a permanent, fixed resident. If it is a shed and you're living in a shed, that's not fixed. Our law doesn't, we have building code and we have laws that state what qualifies for you to live in a structure. Now, you can live in a tent for a period of time. You can live in a temporary structure while you're building a home. This is beyond the scope of those details for this board, but they're all relevant. Because here we have a person that's running for an office that requires integrity and truthfulness, and not to state that he is not, but what he has submitted doesn't appear to align with the requirements for him to be able to run for this office. And I'd like to refer you to exhibits A, B, C, and page 1 of C, D, and F in support of my testimony. I ask that you uphold my challenge. And I further ask this board to consider that one of the statements is made by this candidate that he recognizes that he may have to obtain a surety bond. Now, this has happened in our county before, where a person, I believe, took office and then could not obtain a surety bond. In light of the bankruptcy filing just days before filing his Can 2, in light of no reporting of a job on the Can 12, it asked you to list your employment. When you list a corporation or an LLC that you might be a member of or as a manager of, that does not constitute full disclosure of your income, because I can belong to one of these organizations and receive no income. It depends on the structure of that. But you are required to report your employment. And if you're self-employed, if you're a counselor, whatever it might be, the Can 12 has to truthfully reflect that. And I stand and ask that this board deny, or they uphold my challenge, and they deny this individual from appearing on the primary election.
Does that conclude your
I'm
testimony?
yes.
Okay, thank you.
Thank you.
Nick, would you like a rebuttal?
If I might address the questions to Nick, I think I could get us quickly through him. Nick, why don't you come back up again? Could you provide us a little more detail of the structure in which you live?
It's a 12 by
rooms?
24 shed, and then I've attached a couple other sheds that I tore down and built up around it for an extra room and a bathroom. I compost, by the way, as far as septic stuff is concerned. Here's a receipt for me paying my property taxes. I don't even know where the idea of years behind came from, but I believe that they changed the payment system for the property taxes, and I don't know if something didn't carry over or I didn't get a message or something, but paid it maybe late, but paid it, and there's nothing owed on my taxes. My father's name is not Nicholas, it is Nick. For a period of time, when I first had the property, I was having bills sent to my house before I had a mailbox, my dad's house. I have formed a number of LLCs over the years that have been in name only, haven't been conducting business under them. This is a form that I understood to be about my financial interests. Having a name associated with an LLC is not the same thing as conducting business under that LLC. So I put down the one in which I would have potentially been making money, which was my partnership with the counseling and the sober living home that I was a part of. That is no longer even a thing, so this form is out of date.
I think the only other one I was going to mention is there is some truth and wisdom to the fact that your bankruptcy filing and current situation economically may have impact upon the ability to secure a bond, okay? I only pass that on in just an observation, okay? So that's a thought you might keep and all.
I also DoorDash and have a bit of savings. It's not that I like destitute.
Yeah.
But your form acknowledges that you may have to seek such a bond, and you signed that. Right. So.
Can you clarify for me what it means to seek the bond? Is that the?
For certain offices, you have to seek a surety bond to.
You have to obtain one.
Obtain one.
Gotcha.
And you're, by signing that form, you recognize that you might have to obtain one. I don't know that whether you can or can't is germane to the form.
Due to the financial accounting responsibilities of the clerk's office in particular, there would be a surety bond required.
Yeah.
There's a $300,000 bond
Required.
required.
And then the question on that would be, does the bankruptcy preclude the qualification for that bond?
But I don't think that's a matter for us.
No, it is not.
It is not.
It is not.
I don't think that's our
Oh, by the
our
way, I
job.
believe in your bankruptcy petition, you use the address that you have given here as the
Correct.
address for your bankruptcy. And the bankruptcy petition is like 50 pages long of detailed information about your financial background, is that
Right,
correct?
and all of the details of
Under
the
oath.
property and what I do and don't own, and yeah, it's as detailed and scrutinized as it can be regarding where I live and what I have.
Okay. Did you have any other questions on that?
I don't think I do.
So the question, as I understand it, would be, does that structure qualify as a residency?
Oh, that was the thing I didn't address. She seemed to misunderstand what the assessor was saying when they came out. They said it would not be assessed as a home site because of that permanent structure, or because of that permanent foundation distinction. It's not that they wouldn't assess it altogether. I'm clearly getting assessed because I'm paying taxes, but it would not be assessed as a home site.
And your
until it was on a
taxes, do
permanent
they
foundation.
show just taxes for vacant property, or do they show taxes for structures, assessments on those?
It doesn't, I have, actually, do I have that document with me that says I think that was included in the forms that got sent to me. There's like a section 9 and a 2 that it's assessed under, oh, there it is. So it says, assessed as, section 526. So it says total res 0, total non-res 32,000, total non-res 12,500.
So they are apparently assessing the structure, but not calling it a residence. Well, I'll give you a moment, in a minute, Pam, for the,
I'm not familiar with the ins and outs of how the assessor's office works.
okay. Any other questions? Okay, thank you, Nick.
Thank you.
Thank you.
Pam, would you like to make a
Yes, I would.
comment on the, okay?
The first rebuttal I would like to address is regarding the statement that his father's name is Nick and not Nicholas. Only by evidence of the records you have in front of you and what we have filed at the county, Nicholas' address is 9731 Polk Street. So he did not address if he has a brother by that name.
What are we talking about? My dad's name is Nick. My name is Nicholas.
No.
My dad lives at that address. It is a mailing address that I had some mail sent to at some point. I cannot believe this is the nature of the contention right now.
So as my rebuttal on that is we have a Nicholas in our records showing that tax records are sent to Crown Point, Indiana, to Nicholas. Now, he states that that is not his father's name, and that would be Nick. So then in our records of the treasurer's office, we have Nicholas, them with 2 addresses, one here in Poland and one in Crown Point. I can't answer the intricacies of that, but as you go and you look at the deeds that I provided you with a copy of, we also have reference to Nicholas at the Crown Point address. Second matter, regarding the property card. Now, he did say he had paid taxes. I did not have an opportunity to see that document, but you have in front of you a copy printed by the treasurer's office just yesterday or the day before, indicating the back taxes and that they were not paid. Did they come in electronically while I was there? Possibly, but I can only present to you what I have. But regarding the property card, I can address
And how
that,
do you see that as relevant?
because he,
His tax, his
as a
tax
matter of
circumstance?
taxes,
Yeah, how do you see that as relevant to his
it
revenue?
is relevant because the taxes are not assessed towards any residence. The taxes, in trying to get evidence of a permanent structure at that property, the tax records, when you look at this form that you were provided, at the top of it, it shows that it is a vacant platted lot. A vacant platted lot,
But that has nothing to do, I mean, it may be relevant to the point you're making, but it has nothing to do with the tax delinquency, one way or another.
no, sir, but the record that I presented to you,
Yeah,
in trying to determine if this person lives at this address, this record was sent to Crown Point, to Nicholas.
Pam,
At this address.
Whoa, hang on now.
Yes, sir.
Pam, can you refute the idea that he has been living on this property for 8 years, that he's received mail there, that he has utilities there? I mean, can you refute that?
I have, I do not, I don't have challenge to say that he did or did not live at that property for 8 years. Okay. I do, however, can challenge if in 8 years he's never paid taxes on a structure.
That is not the issue. The
It's not
issue
the
is
issue at
whether
all.
he resides there, okay?
The issue is, what is the definition of residing for running for office,
But
which is
you're torturing that now, okay? Residence means where you intend to reside, where you spend your days, or where you put your head on the pillow, okay?
Okay, sir, so in response to this, although this should be in a finding of fact, I actually provided you with the statute and the exhibit that shows when that law changed. It was previous that the interpretation of that law is where you lay your head at night, where you intend to reside and return to. The law changed. For the purpose of running for office, they clearly list a qualification that removes your concept of what it was just a few years ago
That's
to now
just
that it
one
must.
element, but we're talking about the other elements
Okay.
as well, okay?
Okay, and so may I finish my rebuttal on this, and then we can. So regarding the property
Please,
card
quickly.
that was filed, this property card shows no assessment on any structure.
But it
No
does,
shi-
but it does show a home site's value,
Right, so the home
12,500.
site, the home site value on every parcel, this is in a subdivision. So in a subdivision, the assessor can go through and say, 1 acre of this property will be assessed as a residential land type. That land type is type 9. You will find that even on vacant lots, because if that property has the ability to be used as a residence or for a home to be built on it in a subdivision, then the assessor assesses that parcel as a land rate for type 9. If you notice that he gave a 50% influence percentage deduction to that, that is normally, the intricacies of that is noting that there's not a particular improvement to that property, and it would cost that landowner money to put in, say, septic or water or equivalent. then the tax assessor gives a percentage discount to reflect the change of value. So in this land code, all property is $25,000 for 1 acre. In this particular area, there is a 50% influence decrease. But you have no record of any structure, no shed, no building, no house being assessed for any time period. So
Nick, hold on.
if any time during 8 years, and this would have been assessed twice at a minimum,
Can you give me a yes or no to Mr. Loren's questions? Can you in fact refute Mr. Pasenica, thank you, statement that he has lived there for 8 years? Yes or no? I mean, we can look at all this, and we have looked at all this patiently. But can you refute his assertion that he has lived there for 8 years? Yes or no?
he's provided no evidence and testimony to show that he has resided in a true and fixed permanent resident at that location.
Why
Thank
is
you.
his testimony that he lived there for 8 years not adequate testimony that he lived there? Why is that not sufficient?
With
Why do you
utilities.
disbelieve him?
With utilities.
You want to see my house? I took a picture.
Sir,
Don't Nick.
in my challenge to this, I identify that it's not a matter of a person can say they live on property, that this is where they reside. They may get their mail there. But does that meet the requirements of our state law now for holding office? That is why
Fair
I
question,
put this
and
before the board.
And we will take it under consideration.
Yes.
Yeah.
Thank you.
Thank you.
Yeah.
Okay.
Do I have to stay for the rest of the meeting?
Yeah, you get a shot.
You get one more
Yeah,
Well,
rebuttal.
I don't need to say any more. Do I need to stay here once our portion is done?
No, but I think it would be in your best interest to provide copies
Sure.
of the utility documents and things that you referenced in your testimony.
May I make an addendum? Because I have not got to see his record. So a utility,
Why do I have to provide you a?
Nick, hold on,
a
please.
utility bill does not reflect that that is where you live. A utility bill could be to run barn lights. Likewise, law does not accept if you have a mailbox, that is your home or your residence. You can.
We will take this.
We will take
Thank
all
you.
that into consideration.
We'll
Thank
look
you.
at that. Thank you.
Okay. All right, let's move on. Thank you both. Norm?
Would it be okay if I go next? I'm shorthanded at the office because I had somebody out on vacation this week.
Yes, so we're gonna take a quick recess this time, just for a restroom break, and then we will come back and we will go ahead with yours. Okay?
It was my understanding that we would have a lunch break. I actually have to eat something. It's 12 o'clock.
I did not see that in our original declaration. Is it in there and I missed it?
I can live with it or not. It's up to you guys.
We
Was that
have
part of it?
3 more to go through.
Yeah, okay, I think probably a lunch break would be warranted.
Pick a time.
Norm is indicating by his demeanor, he really
Right.
would like to be.
Right, so I say this, let's do a quick restroom break, then we'll take Norm's, and then we can talk about whether we're gonna take a
Can we
short
have
lunch
like
break.
15 minutes just so I can eat something real quick?
Yeah,
Okay, thank you.
that's fine. We're gonna use the restroom real quick, and then we'll get you going, Norm.
I'm next. Not you. I am.
reconvening, excuse me, our hearing. And our next witness, or candidate, rather, will be Amy Meyer. Okay, Amy, raise your right hand, please. Do you swear or affirm under the penalties of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Could you state your full name for the record, please?
Amy Meyer.
Okay. Go ahead and have a seat, please.
I don't have any of my paperwork with me. I
Okay.
took off in a hurry and didn't grab it this morning.
Okay, I'm going to ask you if you can attest that that paperwork was that was given to you was the paperwork that you filed?
Yes.
Okay. Did you notice any errors or omissions on those forms?
No.
No? Okay. Not to your knowledge, anyway?
No.
Okay. Then the next one would be irrelevant. So do you understand that Challenger has identified a number of discrepancies and deficiencies that she has observed in your documentation?
Okay.
All right, we'll go through those one at a time.
Okay, thank you.
All right?
I haven't filed that yet.
The challenger says that the candidate did not sign under oath. And one moment, I've got to get to the correct page again.
Mr. Wilker, I believe one clarification on that. I believe this is a similar situation we have where all of the items 7 through 13 have got the initials and various answers. I think the challenge is to the adequacy of the financial reporting.
Okay.
On item 12.
Okay, great, thank you.
Can't 12?
She does, they do list on here that they didn't sign, but we can see that there was, so, all right. Okay, and you did sign. All right, and we agreed the challenge is contesting the answer to item 12 only. Okay, which is, we'll let the challenger go through. So her contention is, on number 12, the challenger's contention is.
On can two?
Yes, on can 2. Sorry, because she checked yes, the contention from the challenger is that the candidate did not file or correctly file past financial reports, and according to her testimony that she's given on all of the cases, or many of the cases up to this point, is that if they did not file one of those forms correctly, and yet they checked yes, then that's a false statement, is what is.
I don't have the backside of that, so.
Oh, gotcha,
I just
gotcha.
got a single-sided copy.
Okay, okay.
But it's the same one we've heard before.
Gotcha. Do you have did you have a previous candidacy in which you did not file timely campaign financing reports as required by law?
It's possible.
Okay.
That's been 11 years ago.
Okay.
I don't exactly remember, but I only had one thing. I've only had one thing to file.
Okay.
It was like $100, and that was 11 years ago. I haven't taken money, haven't
Okay.
spent money, so it's all zeros
Okay.
for every campaign I've ran.
So on the CFA requirements, I believe we had this discussion at some point, you and I did, Richard. I think is the rule if it's 500 or under?
At which you would not be required to file a financial report.
And I'm going to put a note on here to check that. I believe it's $500, but I don't remember that for sure. Yeah. So, hang on just a moment. Okay. And so if I'm understanding you correctly, there may have been one form that you did not file from your previous time about 12 years ago that you ran for office?
There may have been. I'm not sure.
Not sure, okay.
But like I said, I've only taken $100 one time.
Gotcha.
And that was 11 years ago when I first ran and lost. So I haven't received any campaign money, so it would be all zeros.
Okay.
But I'm happy to fill those out if I need to.
Right, okay.
But I haven't received campaign money at all.
Okay. Did you, and this is a question for that, and that may need to come up in a different hearing, I don't know, but if, did you purchase signs with your own money? Was there anything, did you make purchases for that campaign over $500?
No.
Okay, okay. And then we're not sure if there's a residency challenge on that.
There's one more challenge that we need to be addressing here. On your candidate 12, financial economic interest and all, okay, you have answered a couple of questions on there, but there are many that are not answered, okay? Things like the name of my spouse and various other kinds of enterprises you could be involved in. There's no NA, like not applicable, or any other answer to those questions at all. Is there a reason why you did not answer those questions?
No, I asked Miss Linda
Go ahead. I'm
for
sorry.
help to fill it out, and if it didn't get filled out, I fill it out in front of her. And I asked her how to fill it out, but no, there's, I mean, if it's required of me, then no, there's no reason other than I didn't catch it, or it wasn't applicable.
You understand, of course, the clerk's office is not able to direct you as to how to fill out any
No.
form, answer at all.
No,
And they
just to
have no
make sure
duty or
that
responsibility, that's up to the candidate and all.
That's not what I'm saying, I didn't understand.
Things such as the name of your spouse, however, would seem to be relatively available to you unless you are not married.
I am married, yes. There's no reason that I would not, I mean, everybody knows who my spouse is, honestly, in this county, so.
Well,
No, I didn't.
everybody knows
I didn't mean
your
that.
spouse does not qualify as an
No,
answer.
I didn't mean that, I don't mean anything by it, I just want, I have
Yeah.
no reason to
So-
hide my spouse's name.
Okay, so,
all. It was-
so if you had boiled it down to a reason that you left those blank, what would that be?
I overlooked it.
Okay,
Okay.
that's fair. We're
You know,
gonna
That's a
go with
legitimate
that.
answer. We've heard it before, yeah.
Yeah.
and I'm willing to work to fix anything that I might have to.
Gotcha.
Didn't do any of it on purpose.
Okay.
Let's quickly answer some of these other questions. Who is your employer?
Who's my employer? I work for, I guess, my husband's company,
Which is?
David R. Murray and Associates Land Survey,
Okay. And
LLC.
do you have any professional practice? You aren't a surveyor yourself, are you?
I'm a survey technician.
Okay, so you have a
I'm a
professional
land
practice. Do you operate under the name of the David Byer?
Yes.
Okay. And are you a member of any partnership or corporation?
No.
Okay. And are you a member of any limited liability company?
No. Other than I work for,
Are you an officer or director of a corporation?
not that I know of. No.
Do you have a official title of a corporate structure or management structure in David R. Myers and Associates?
Can you explain to me what that means?
It means, do you have any official capacity in that entity?
No.
Like, are you a secretary or treasurer or anything like that?
No, I don't have an
Is
official
it a
name.
corporation, or is it just a name, a trade name?
No. It's,
Just a sole proprietor?
It's an LLC.
It is, okay.
It's an LLC, but no, I don't have any. I'm not.
You're not listed on the LLC as an officer
I'm not
or
listed
any
in
other?
paperwork or
Okay.
anything like that.
Gotcha,
And when
okay.
you say you work for Myers and Associates, that's because he's your husband and you're part of the, or do you have a job title there specifically?
I don't have a job title.
Okay.
It's not.
But you did state that you're a technician, a surveyor technician?
I have been assisting him, yes,
Okay,
for
gotcha.
a long time.
You're in charge of the yardstick?
Huh?
So that means you help with this, with the surveys, but you're not licensed as a surveyor,
No,
correct? Okay.
which there are many survey technicians that work under licensed
Sure.
surveyors that are not licensed.
Oh, I'm sure,
Okay.
yeah, yeah. The one other, just following with, along with what Richard says, if my spouse was a member of a partnership, the name of the partnership and the nature of the business was, in this case, it would be Meyer and Associates Surveying, or?
Yeah, I
Okay.
guess. David R.
What's his official title, or official name of the business, of the company?
David R. Meyer and Associates Land Surveying, LLC.
Perfect, thank you. Okay. All right. You already answered that one. Okay, and that one by default, we know the last one on that. Did you have any other questions on that Can 12, Richard? Okay, and just for the record, the Can 12 was signed and received by the clerk with the statement and the clerk's seal. And then on the front of the document, it was stamped as filed as well. Okay. Any other comments that you'd like to make, Amy, before the challengers comes up?
Is that the only thing that was brought up?
Yes, so those items, the 7 through 13, her contention again was number 12, because there was, according to her, there were previous forms that were not filed, forms that were not filed, and you answered number 12, yes, meaning that, yes, I have filed all my forms.
Okay.
Okay, but as far as I can see, there was nothing missing. You didn't miss any of those. You initialed them all or checked yes or no on them.
Okay.
Okay, and then the other issues that the attorney just raised with Can 12 were all of those forms or lines were blank. Okay, all righty, thank you. Pam?
1 second. Thank you. I offer into my testimony evidence package the materials that you have in front of you. And I also have a copy of the statements I'm going to read that I will provide to you. I can either give them to you now or after I read them, but I do have that. I believe there's confusion underway when you start off to say that I filed a Can 1, and you're referencing that I state that something wasn't signed, or are you going off of a spreadsheet? Because that spreadsheet is inaccurate. And I draw your attention to...
We're going off your evidence.
Yeah.
Right, so I have a copy exactly of my challenge.
Okay.
And number 6 on the challenge states, did not complete the Can 2 as law provides. See attachment, paragraphs 1, 2, 4, 6, 7, 9, 11, and challenge to residency address. Now, I do not state what you stated, so...
Okay, okay, so for
Here's what we have here. We have what you filed.
Correct, and it states on number 6.
Yep.
And
it has...
then my attachment, yes.
Your attachment.
Yes,
Okay.
I agree with that, but that does not align.
Well, let me change my wording then. I said your contention was that the candidate did not answer the questions on 7 through 13, but then I clarified that to say your contention is that she signed number 12 affirmatively, yes, and your contention is that there were previous forms that were not filed.
Correct, and a further scope of that, so.
Okay,
So
okay.
it's beyond just that.
Okay,
But I just wanted to
gotcha.
get that clarified.
Sure.
My statement, my general statement then regarding the Can 2 applies to this candidate as well.
Okay.
And I reaffirm number 1, that affirming to truthful statements being made, and number 2, that it has to be completed. And number 4, that any individual can be challenged. Now, if you notice, I don't have residency number 5 marked, but I have residency address included in my number 6 statement, because that is a different matter than how it is worded in the attachment here. We will address that in just a moment.
Okay.
Number 6, again, is regarding the number 7 through 13 with an emphasis of being answered untruthfully or completely. Number 7, that I filed all reports. And number 9, that Can 2 may not be amended. And in number 11, that a CAN 2 serves as a notice that you do not have delinquent forms. Now, Ms. Myers started off with making a comment regarding that her forms that she referenced were potentially for, I think, 11 years look back regarding her candidacy. Amy Myers is in office now. Amy Myers has forms and uncompleted documents from her current position as the county surveyor, not 11 years back. So that point was not addressed when she responded, that my challenges and the package I put together is for the CAN 2 filed now and the look-back period for her current position.
And I'm sorry, Pam, I don't see on here a reference to which forms that you said she was missing from her current. Are they in that supplemental information that you gave us?
Yes, and that is in my testimony that I will be addressing here.
Okay, gotcha.
So, going through the CAN 2, line 1 is complete. She does not provide the township or county in her answer to line 1. This is by statute a requirement that these two items are included completely in your application. Now going to line 5, the address. The address used.
Oh, I'm sorry, I'm looking at the wrong form.
We're looking at the CAN 2.
Okay, sorry,
Yeah.
yes, go ahead.
And
So-
if you go to the color version, I have things highlighted as we walk through those.
Okay, so you said that she does not list the township?
That's correct. So on
But-
line 1, township is not marked,
Okay, on mine,
or county.
it says right on here Franklin Township.
No, sir, that says precinct Franklin.
Well, we don't have precincts in Owen County, and so the townships are allowable to be listed as, in lieu of the precincts.
But we
When
do
we
have-
became, when we became a voter, a vote center county, we no longer went by precincts, and that is a known fact, and has been a known fact for, ever since we become a voter, a vote center county. So the proper response to that line is the name of the township that they live in. We don't have precincts, so it is Franklin.
I respectfully can only go by the documents provided to me by the clerk's office, in which there is a precinct map where there are precincts listed.
Those precincts apply to county council and commissioners that run in a specific precinct rather than an at-large. When somebody's running for a county-wide office, the correct response is just the township that they live in, or that they're from.
Okay, that matter I will take under advisement,
Okay.
but I did receive a document to identify what the precincts were for each township. But,
Yeah, the
So-
precincts on particular townships no longer apply, and haven't since we become a vote center. Go ahead,
In
I'm
the
sorry.
in the abundance of caution area, I would note that there is a precinct identified first, and the next blank is the township, and this word Franklin appears in the precinct south.
Oh, okay, so it could have inadvertently been put in on the wrong line. Okay, very good.
that matter, what will need to be further addressed.
Okay.
County is listed, is off. Now we go down to number 5. My complete residence address is 7171 Goose Creek Road, Freedom, Indiana.
Okay.
There are 2 parcels under the name of David Meyer on Goose Creek. 7171 Goose Creek mailing address is not assigned to any parcel in the county treasurer records. To date, there is no building permit, certificate of occupancy, or permit to obtain an exception to building a permit or log cabin exception that was located in the building department looking back through 2026, 2025, and 2024.
Okay.
The Myers residence at 653 East Porter Ridge still carries a homestead deduction. The most recent property card on record by the assessor's office as of February 23rd, 2026 indicates no residential or building improvements at this Goose Creek property. The address on Porter Ridge which is the address used in her current candidacy, is in a different township. So Exhibit C, residency is stated as a person's true fixed permanent home and principal establishment. Although I admit that both addresses are within Owen County, I challenge the correctness of the Goose Creek address as a fixed and permanent home in light of no required evidence of occupancy or permits to show that that's actually the residence. So they have two residents now. So Amy is showing Porter Ridge and she's showing Goose Creek Road, depending on which county document you look at. I'm only proposing this because it is a change from one township to another township. And if in fact there is no home or structure that they're living in, and I've heard that possibly they're building a new home at that location, which is the address that's legally and formally her residence.
Okay.
Because it makes a difference in not particularly this CAN 2 in her candidacy now, but for further clarification as to which township her vote is to go to.
Very
So,
good. Duly noted.
yeah, so that is why that is placed before you.
Okay.
Under number 12, okay, under candidate certification, states I have filed all reports for previous candidacies, and she marks yes. To address this challenge, a little background information is needed. So there's no CFA 1 was located for Amy's 2022 initial filing for surveyor. That doesn't mean that it doesn't exist. It just means that I've not been able to locate it with my record search. Hopefully Amy has a copy of that. However, a CAN 2 and CAN 12 were filed. And in the 2022 CAN 12, Amy correctly completed this document. She filled in all the blanks as the form recommends that you do. Not recommends, but states you must do. Unlike the CAN 12 filed on January 13th that is required to be filed together with her CAN 2. The 2026 CAN 12 does not fulfill the requirements to satisfy the signed statement, which states, I, the undersigned, affirm that the information set forth on the Statement of Economic Interest is true, and I emphasize the word complete. You will find this supported in the exhibits that I provided with the statute and line-by-line instructions as to what is mandatory, not optional. And you will even notice on the CAN 12 that it is highlighted in bold as you start that note, insert not applicable where appropriate. Given that immediately above her name in orange on your sheet, it states insert not applicable where appropriate in bold, it's not something you can just overlook. It is a further confirmation to inform that candidate of the requirement that each line is answered completely. Additionally, Amy does not answer the very basic questions, which has been addressed. And I also note that she does not report her government income. Now, that's not required unless her income is less than 1/3 of her total personal income. So your counsel did address why she's not showing her revenue source or employment or job, but I again emphasize that she does not report her revenue from her position as county surveyor, which I believe is approximately $28,000 plus in that vicinity. So that is a matter that should be addressed. A true and complete CAN 12 is the definition of executing and filing a CAN 12. If this isn't true, when a candidate could just turn in a blank form with only a name and a signature. So in effect, what you're saying is, if a person leaves all of these blank and they don't fill them in, that we should give them a pass, or what are your answers for that? But that also promotes, that's the same thing as not filling in a Can 12. Otherwise, you're saying all you have to do is put your name at the top and sign it, and you've met the requirements of filling a Can 12. I emphasize the importance of this because the law states a Can 2 may not be accepted. It must be rejected by the clerk's office. Now, it doesn't state when it gets rejected. Does it get rejected by the clerk's office during a CEB or at a later point when it's reviewed? But a Can 2 must be rejected if it does not include a Can 12 filed at the same time as the Can 2. So before you is the question that needs to be addressed is to what constitutes that? Will you accept just my name and a signature and that completes the requirements of a Can 12? Or will you follow the statute set by the state of Indiana that says specifically what is required to meet the standards of what a Can 12 is? And at that very minimum, it's answering the questions. This was not done. So Amy was given notice. Let me back up one here. Although I do not have a copy of the CFA 1 from 2022, a CFA 4 was filed on 2/6/2023 as a final, line 11. This is important. The reporting period, albeit incorrect, lists 1/26/2022 through 2/1/2023. An annual report was due on December 31st, 2022. None was filed. Amy was given notice by the party chair and through the election office that a law change required a new CFA 1, to be filed if she had closed out her previous committee. And the CFA 1 was due to be filed by July 11th, 2025. She did not file a new CFA 1, not until January 13th, 2026. The CFA 1 states the committee organization date is 1/1/26. That's line 20. Unless the law states that this CFA 1 has to be effective July of 2025. So again, this is a missing document and incorrect document. But then on line 13, she again uses a completely different committee name than that which she uses on her CFA 4. That's another violation of your election law. On January 14th, 2026, she filed a CFA 4 as a pre-primary, which isn't even to be filed until April. Now in this, she assigns a new committee name, line 1, and then leaves line 12 blank, which is the reporting period. She lists herself as treasurer. By leaving this line blank, this is an intentional, knowing effort to not indicate what this period is. And this then makes it confusing for you to administer or even to know if this is a defective filing or if this is an intentional changing or absence of filling in the information. But at a very minimum, this period is important. Without this reporting period and the date of when your committee is established, all your other records are offset. Now line 6 includes an email address. And I want to emphasize this. Line 6 includes an email address that is a county government email. The use of government resources to facilitate the committee to elect Amy Meyer for county surveyor is a use of government property to promote a campaign. In her signed statement on the Can 2, she states she understands the requirements of her office and of the finances, and within those documents and within her oath of her present position, the use of a government email in a campaign document is prohibited. This needs close attention and detail by this committee, please. Amy knowingly filed a CFA 4 one day later that intentionally did not list the reporting period, line 12. Each comment I have here is highlighted, and you'll be able to follow through with the document I'm giving you. She was aware that she had neither had filed a CFA 1 in July of 2025, which was a law that went into effect, nor filed a yearly report for 2025. I emphasize the warning that appears at the bottom of the CFA 1. Any person who knowingly files a fraudulent report commits a level 6D felony. A person who fails to file a complete or accurate report, as required by the Indiana Campaign Finance Law, commits a Class B misdemeanor and may be subject to civil penalties. She read this when she filed her report. Regarding line 9, she initials that I might be required to complete training or have attained certification related to service in office. To date, the State Board of Accounts, Department of Local Government Finances, AIC, and records within Owen County have been unable to verify she complied with statutory training requirements. A record request was formally filed to obtain a copy of the verification that she had completed the training requirements. Amy denied the record request as county surveyor. Amy Myers is not a licensed surveyor and is required to obtain training for taking office as well as yearly compliance. She has not been able to demonstrate that was completed. There are no records on file to demonstrate that was completed. An exhaustive attempt to locate these records have been made. It's evidence that she does not regard her sworn statement that the information on the declaration of candidacy is true and complete, and that I meet the specific requirements of this office. Under IC 3827, Exhibit A, Section 7 states, the declaration of each candidate required by the chapter must be signed in before a person authorized to administer oaths and contain the following information. Emphasis. 7A2, location of precinct, township, and county. 7A1, a copy of the statement of economic interest in the emphasis. And 3, the candidate may be required to successfully complete training, which she did not do. Further, Exhibit B provides Indiana code for the requirements I stated in my challenges. Pages 1 through 4 address these details. I submit Exhibits D, E, F, G, H, I, J, as well as previously referenced Exhibits A, B, C in support of my Can 1. I request you uphold the Can 1 challenge to allow this person to appear on the primary ballot. She should not be allowed to appear. In addition, if the CEB does not uphold this challenge, I ask that you conduct a full investigation into the content, truthfulness, and intent of Amy Meyer in the documents submitted to appropriate bodies to facilitate a comprehensive investigation into the matter before you.
And when you say submit, are those articles of evidence that you will give to us, is that what you included in this package?
Yes, sir, those articles of evidence are in there, and the addendum to that is I have written statements, and one for Amy as well, as to those facts that I just read out to you, to be supplemented to my filing, only to help you navigate. I speak in a hurry, and sometimes it's difficult to follow. And Amy, I have a copy for you.
Out of curiosity, Richard, is there, when a challenger signs a Can 1 challenging,
Where's the document you said that you have?
do we have the right to ask them who's assisting them in this challenge? And who's doing all this research?
You can, although I'm not sure that it has any particular weight to do anything or relevance, yeah.
Yeah, just curious. Okay. All right. Where I was going with that is that
At
an
this point,
outside...
you need to have her return.
Yes, go ahead
answer a few
and come up,
questions that
Amy,
come
for
up.
your rebuttal. Would you like to answer any of those challenges that she said?
It's hard to follow some of it, honestly. I'm a little bit,
Well, let me just take the first one. She said that we've already addressed the CAM 12 issue, that those were not completed, or that it was not completed. The second issue, if I recall, that she brought up was that that you had been informed by the county chair and perhaps, and maybe I missed that, perhaps the county elections office, that there was forms that the law had changed and that you had to file the CFA 1 or refile the CFA 1 that was due back in June or July. Is that what she said?
It was due in July. We got it, we were at conference and we were told about it. I went straight from vacation to there. We contacted the head of the parties. I contacted people back here. It was also emphasized to us that it is the candidate's responsibility to find out when these laws change.
Okay. But it was communicated to the various candidates, including Ms. Meyer.
Well, we sent out, I was not here, they sent out to the information that they have.
Okay.
So, once again, they are responsible for
Gotcha.
that.
Do you remember receiving any of those? Okay.
no.
The next thing that I had written there.
Let me, there was a question about your address that you use.
Yes, thank you.
Where is it that you live? That is to say, you and your husband, I assume, are in a single residence, is that right?
Yes, we live at 7171 Goose Creek Road. There are building permits on file for there. I don't know what she means by that. There
Okay.
are building permits acquired.
Are you in a temporary structure now until the building is completed, or?
No,
No?
they are completed structures.
Oh, gotcha, okay.
I live in them. But my residence at Porter Ridge was hit with a tornado May 16th.
Okay.
Could not live in it anymore.
Yeah, okay, gotcha.
And so we moved in a lot quicker than we were expecting.
Gotcha.
Over at Goose Creek. But I find it disturbing that people look into where I live and the buildings that I have on my property. That is not an assessor. But
What is on the Porter Ridge property now? Anything?
my house and the barn, but I mean, nobody lives there.
You mentioned the tornado came by and did damage.
Yes, and they had to come through the insurance and just like a lot of people around here had
And
to.
are you going to rebuild at that location too?
No.
Okay.
My permanent residence will be out at Goose Creek.
Okay,
That
And
was,
that's where you live now?
that's where I
Okay.
currently
Right.
reside.
okay,
And I changed the address form with the elections office back in October.
gotcha. Okay. So, and on your new application for candidacy, you list the new address out at Goose Creek?
Yeah.
Okay,
But for my other candidacy, we didn't live there.
right, you were
There wasn't
still on
anything there.
Porter Ridge at that
Yes.
time? Gotcha.
So, I mean, that wasn't, and I didn't intend to deceive anybody
Right,
on any of that. And my government email that was a misunderstanding. That's the only email I actually use
Okay.
in my daily occurrence because I have one email, but I never open it. I don't use it for personal emails. I'm not a tech person, just the government email. I wrote it down as a habit.
gotcha. Okay,
I can put a different email. I've never used my county email as political or anything else. I mean, so I don't
right,
appreciate that being implied. Also saying that I intended, that word, she keeps using intended. I intended to deceive you. I intended to do this or whatever. It's not true.
okay. All righty.
There was
If I
also a
did something
question about, have you changed the names of your campaign financing
Not-
entities?
Not on purpose. I'm the same, I'm the treasurer. I've been the treasurer since I ran originally 11 years ago. if the words are a little bit different, I didn't even notice. I'm sorry. And you're right. That is my responsibility. I take full responsibility for all of this paperwork that wasn't filled out correctly. I'm not trying to pass the buck on to someone else. I take full responsibility.
Okay.
But I'm not sure where some of the things that she's brought up has anything to do with these papers, like the training and things like that. Is that you people that has to do with my training?
No, the
No.
county election board does not
Okay.
perform training for anybody. So if I understood her challenge on that, that was going to be my next point that I brought up. If I understood her challenge on that, she's saying by virtue of the fact that you signed the form, you agreed that you would complete whatever required training for the office. She's saying that there's no record of you completing that training. Did you have an orientation for your surveys position? Was there
I've
any
never had an
training
orientation.
required?
Never had anything like that.
Okay.
I had
So,
to talk to the State Board of Accounts
okay,
about all of these things.
gotcha.
Because she turned it all in October. And we all had a meeting with the State Board of Accounts. Just because they haven't told anybody else what they said or their findings and conclusions.
So did the State Board of Accounts give you any direction on that when you,
They told me to spend the corner perpetuation money on the
to
corner perpetuation.
do the training?
No.
Oh.
They didn't say anything about my training because I work for a licensed land surveyor.
Oh, okay. So because you work for a
They
licensed
didn't-
surveyor?
They didn't think that was the most important thing that was
Okay.
brought up. They thought the most important thing was to spend the money on the corner perpetuation. And I agreed. That is the most important thing for my office.
Okay.
And so that's,
So you did not receive any type of correction from the State
I've
Board
not
of
been,
Accounts
no,
regarding
I've never been
training?
reprimanded, nothing.
Okay.
They just, that was it.
Okay. I'm not personally familiar with what the training requirements are for that position. If a person is not a licensed surveyor, I don't know. That's something we'd have to look into, I guess, but.
There are certain requirements that the state would like to see in place. If the State Board of Accounts had some conversation and decided that they did not want the county to spend money for training but preferred corner preservation, that was be their thought process.
Right.
I'm not sure it's within the realm of the election board's decision-making power to have any impact on that question.
Very good. Thank you. Okay. Anything else stood out to you that you'd like to refute or rebut?
I have a question or two. You're in office now, right?
Yes.
When did you take office?
This is my last year, so.
I'm sorry?
2022?
I don't know. I'm
January
asking you.
2022?
This is the last of a four-year term, so the last year of a four-year
Okay.
term.
So you were elected to that position?
Yes, sir.
Were there records from those campaigns, that campaign?
There should be.
I'm just asking, I don't know.
Do I
Okay,
have-
because that didn't really come up. We were talking about things 11 years ago.
Right. She said the challenger, Pam, said that she does not find or could not locate any records on the
Okay, I
CFA
missed that.
forms
Thank you.
for your current term in office. Is that a correct statement, Pam?
You're paraphrasing, you haven't read.
Okay.
So there was not a CFA one found for her current term, that is correct.
Okay.
She did file a more recent CFA, but there are records that are missing. That does not mean,
That they weren't filed, it just means that you couldn't
that
find.
means that I was unable to get a copy of them when I requested them.
Gotcha.
So she
Okay.
might be able to provide that.
They would have been filed back in '22
I see.
for her to take office in
Okay.
'23.
Gotcha. Okay.
There are
Okay.
other 2022 forms that were located, but that one was not.
All right. I just wanted to clarify that because
Thank you.
we were talking about 11 years ago and then we were talking about
Right.
3 years ago and
Right.
I got lost in the time warp there. Okay. I don't have anything else.
And just to clarify, you said the name of the committee, if you listed it incorrectly, it was just a clerical error. It was not, you did not change the name of the committee, or you were not trying to,
No.
if I'm understanding you, you weren't trying to be misleading, you just listed it wrong. I don't want to put words in
I
your
didn't-
mouth, I'm trying to find out.
Yes, it's whatever I picked the first time I ran, it's supposed to say the same. So
Okay.
if I didn't put the exact, I mean,
So
I don't
you
have
may
any
have
money, I
worded
haven't
it,
received campaign money, I don't have it.
you may have worded
I'm
it incorrectly
and
on
I'm
the
not
second.
doing it.
Okay, got you.
So, I'm sorry,
Yeah,
I'm so confused.
yeah, I'm just asking, I'm just asking,
Just trying-
yeah.
But no, I don't have a committee, I don't, it's me, it's
Yeah.
me.
Okay, all
I
right.
think that's the case in a lot of small
It-
county offices.
It's probably the case in most of
Yeah.
small offices, yeah.
I didn't realize I should have counsel with me today for this.
Yeah, I mean, you could have if you wanted, but it
Could have,
not
but
necessarily.
I don't think that's the intention.
Right,
Or
this,
need. I think
this
you
is
go
just a
fine.
hearing, it's not a court of law, so,
Richard pointed that
yeah.
out. Very fine.
Any other comments that you would like to state on it?
No, I'm sorry that you all had to be dragged in here for this
Okay.
over me. That's for sure. I don't want to waste anybody's time.
Well, our hope is in all of these is to get clarification for all of our future candidates that, hey, let's make sure we got everything lined up and,
I would love to,
And do
yes,
it right.
I
Yeah.
want it fixed, or I want it done right. There's nothing wrong with that.
sure. Very good. Pam, do you have a rebuttal to that? Okay, thank you, Amy.
Yeah.
So I'm going to address rebuttal. First one is towards a statement made by counsel. And a statement was made regarding an incorrect assumption alluding to the State Board of Account. First of all, when the State Board of Account does an audit, it takes 1 year before, from the date something occurs, an audit may occur 1 or 2 years later, then a report is generated afterwards. When the State Board of Accounts does an audit, it's not their duty, nor within their purview, to implement certain penalties and processes. In this particular State Board of Account matter, I actually was involved with, as I had to file a complaint regarding the matter of the survey's office and the perpetuation funds, which have not, by law, by code, those funds are supposed to be used in a certain manner. That's not happened, but this is not what we're discussing in this meeting.
Right.
However, the matter of attaining your training, this is directly related to the statement made on the back of the can too. And her own testimony states that she didn't get training. This is a statutory requirement. And when you sign on the back, it states that you understand what is required of your office and that you will follow those guidelines. When she takes office, she took an oath that she would uphold the duties of her office. Any person coming into office takes a little bit of time to find out what is their job. What are those rules? That's her responsibility. State doesn't come out and hold your hand. First requirement, written by statute, and you have those references, is that before she can take office, she's required to take training issued by AIC, approved by the State Board of Accounts. And this is for any person who takes office. Anyone is required to get training before they take office. There's an exception given that if the timing is bad, you can still take office, but you're required to get that training. Within the time period that you're in office, you are required to get yearly training. Now, she made a comment that because she works under her husband, who is a licensed surveyor, that she doesn't have to get training. That is an absolute,
That's not what I said, Pam.
that is a paraphrase of what you said, that she...
We'll give you a
Yeah.
chance to rebut here in just a moment.
She stated that-
A second.
She wasn't required to get that training. And she also referred to working as a technician under a licensed surveyor. These are 2 points that are important because it is very clear, the statute lists point by point, stating that if you are not a licensed surveyor, you must attend this training. You may not take training online that a licensed surveyor may. It's very, very clear what you may or may not do. And it's evident from her testimony that she's taken no training. The training is not, do you want to take an online course? They list, State Board of Account list, what training is accepted. So it's a combination of AIC and the State Board of Accounts. There are things that you can attend at Purdue, there's conferences. None of those were attended. None of those were completed, which is part of the confusion as to implementing the office of her.
Let
her
me
duties of her
shorten
office.
this a little bit. So your contention is that her CFA 2 item 12 form is wrong, that she's certified that she's aware she may have to do this and that, and is wrong because there's supposed to be associated training and she didn't do it. That's the bottom line here, is that her CFA 2 is wrong on item 12. Is that right?
It is a confirmation that is identical to how she signed it for her current tenure in office. She also selected and marked that.
Right.
That she was aware of that.
That's your contention, is that she
So,
is
in
filled
my-
that out
right.
incorrectly.
Right, and so in my Can 1, she has again signed it, so she's knowingly signing. She is aware that she has to have training.
I think
And-
training is not the issue is the form, and your
Well, but
contention is the form,
The form specifically references training.
and the form references training, and so therefore
Right.
you believe the form is incorrect and thus invalid.
I don't believe that the form is incorrect. I believe that she's made a knowing false statement
Okay, thank you.
on the Can 2.
That-
So
that- I'm
next
just trying-
thing is,
yeah. I don't want to wander around in training, because that's not where we belong.
right, no, it's not on the details of training, but it is that she has admitted not to taking any training. By her
Okay.
Can 2s, she admits that she knows that she may be required to. And so again, she's not met that thing. Now, going to the address, I am sympathetic with the damage to her home and understand that completely. My challenge on the use of on Goose Creek has to do with, I did search at the building department and had them look for the last 3 years for any evidence of a certificate of occupancy or building permit issued, or an exception to the grandfather clause or exception to the log cabin clause. As of just, I believe, 2 days ago, the building department said they had not yet found any such building permit or certificate. In a storm event, okay, there are exceptions, you have to. I mean, things happen. And you can temporarily live on a property for 6 months. And as long as she is demonstrated to this board that that is a legitimate address for her, that's the only reason it was challenged. It's because it did not match the fact that there's still her homestead credit is given to the address that she says that they've not occupied for some period of time. Now, maybe that hasn't caught up. When you look at the assessor's form that I've included in your packet, it shows that this is vacant, unapproved land. So again, this is not me trying to say that she has been dishonest regarding her address. It is only to clarify what her address is because of the disparity in the records and the fact that 7171, that address, is not assigned on records. It's the mapping programs and everything just shows Goose Creek property. So I am being fair and equal against all of my challenges. And I looked at whether if there was a dispute in the address, this isn't a personal vindictive against someone. It's just a matter of compliance and trying to get the paperwork straight. And then I do ask that you do review my packet of documents and the exhibits I gave, because they go succinctly with what I filed and provide you with the statutes and references, et cetera.
Okay.
And who do you assert is the authority to remove a office holder who has not complied with training requirements?
Okay. Specific only to training requirements. Okay. So the candidate, the person in office, is required to retain and hold their training documents and to show that proof. Removing a person from office for not complying with training is a matter that's before the state right now. We reached out to State Board of Accounts and DLGF regarding this training matter because as a citizen, it's upsetting for me to have a candidate in office that is holding that office, collecting an income, hasn't gone through the training, and has not executed the duties of an office, which has brought this full front as to whose responsibility is it to correct these. Now, the State Board of Account will issue in their audit letter, if they notice that a training has not been complied with, they will issue a letter to that effect. However, the documentation of that, the surveyor is the one office that doesn't report their training online like the other elected officials, such as a clerk, auditor, etc. They're in this strange category, and the state's trying to find out why they were dropped off.
Would you agree with me that presently there is no state office that is authorized to seek the removal of a person who is not qualified for the job?
The law on that reads that a county council and the county commissioners may pass joint resolutions to have an elected official removed from office for a failure to execute the duties of their office.
Their elected duty.
Yeah. This then goes to a court for deliberation, but there is a process in place. It goes further to state that in these instances, sometimes the best resolution to resolve a person in office who has not complied with statutory requirements to execute the duties of their office, which includes training, proper expenditure of funds, and in this instance, not executing any corner monument perpetuation records, period, that each year during an election, that removal of that person from office by means of an election is the least expensive outcome for a county.
Sure.
That is in written
Okay.
record.
Well, that would be a given point, but the point is that's not up to the county election board.
No, it is not.
And the way that statement reads is, I may be required to complete training, not I swear that I have completed training.
No, but
on a
by the
signature.
statement that I may be required, so she's acknowledging that she may be required,
Right.
and by not taking training
Right.
and then signing it again, that is further support of the untruthful statement.
So, yeah, so I believe that answers everything. The State Board of Accounts, well, Amy, go ahead and come up for your rebuttal, please.
I never said I didn't take training.
Okay.
I explained to the State Board of Accounts that I do train with my husband. He is required to have a certain education requirement every 2 years, 24 hours of continuing education in the surveying field.
Okay.
And those are $500 courses online. I sit with those and watch those.
Okay.
Now, I haven't found any that I thought applied well to the county surveyor's position. And I explained that to the State Board of Accounts gentlemen.
And-
However, I never said I didn't take training.
Okay, thank you
I
for that
explained to them
clarification.
that we don't charge
Yes, so,
the county for
did
it.
did the State Board of Accounts respond to that? Did they put anything in writing, or did they say anything to you regarding that?
The last thing they said was, what do you think is the most important thing that you're in charge of? And I said the corner monuments, and they said, exactly.
Okay,
So, have you done any of your corner perpetuation? I said, not yet. They said, spend the money on the corner perpetuation. You
Okay.
need to do corner perpetuation. That is the most important thing that they thought
Gotcha.
I
And so-
needed to address.
And
The
so
other
they
things,
they did not say, that's not going to be sufficient training, you need to do
No.
this? Any statement like that?
they never made any statement
Okay.
like that.
Okay.
They saw that, yeah, you sit in on these classes with your husband and you're not charging the county any extra money for education.
Okay,
Great.
All right,
gotcha. Thank you so
Moving on.
much.
thank you.
Did you have any other
I
rebuttals
have a
on
rebuttal to that, yes, sir.
that? Just a moment, Pam. Did you have any others, Amy?
No,
Okay.
I don't like my words being twisted.
I-
Just because I don't go into a grave detail about all of these things and she doesn't have a copy of everything, doesn't mean it doesn't exist.
Gotcha, that's very good.
That's all I would like to say.
Okay, so Pam, just one quick rebuttal, because we need to
Yes,
move
I-
on, so
I
thank you,
have
Amy.
one quick
And I have
one.
family waiting for me.
Yes,
So
no, you're good,
Am
if
I
you want to
okay
leave,
to
yeah,
go?
yeah,
I appreciate your guys' time.
sure, thank
If you need
you.
anything, any kind of copies or anything, please.
Okay, thank you so much.
Thank you.
I'd like to read into record an email received, and I can produce a copy of this. Anton Neff, councilman for the county, referred me to a party through AIC that oversees the training aspect, and I received this email. I'm going to fast forward to the It is responsibility of the elected official to track training hours. Beginning, I believe this year, elected officials will upload information in Gateway Portable. However, I'm not sure which officials might be exempt from the process. There are several options where surveyors can obtain accredited hours, such as Annual Farm Bureau Drainage 101, Purdue School of Surveyors. You have the code site here, but it is, again, for your convenience. Please note the highlighted section. I am again referring into testimony now. IC 36-2-12-2.5 training. A training course refers to, and I'm going to make this short, they go through into exactly what is allowed and not allowed. Amy was not allowed and is not allowed, and they do not acknowledge training that's directed towards a licensed surveyor. The law very specifically states that it has to be approved by the State Board of Account and AIC, which training is required and the frequency of it. So the statute that I just provided you actually confirms that her statement, although it is admirable that she's taken training, but this is from the response from AIC regarding that.
All right, thank you.
Mr. Chairman, is it allowed for public to speak?
We're not doing any public comments, Bill.
I was going to clarify something as a former surveyor.
Oh, gotcha. Yeah, we had chosen early on not to
Just
take
go
public
ahead.
comment.
We're having so much fun. I mean, let's just make it keep going.
I don't want to wander into training anymore, because
Yeah.
that's, the issue in dispute is whether she completed her form correctly.
That's right,
That's the issue in dispute.
That's my
And
point, too,
one
and-
party says, nope, because the training wasn't there, and the other party says, but that takes us over into a whole other area
It does,
of
and the-
inquiry where we don't belong,
And
to
the
be
state,
perfectly
and the
honest.
state, and the State Board of Accounts would be the responsible party for
We have to
issuing a
evaluate
correction
whether
to
we
that.
think the challenger has a legitimate point there, or whether not.
Right,
And- But I
exactly.
really don't, there's nothing, I'd like to hear it, but I
Yeah.
Well, the experience has been that the State Board of Accounts is good at calling attention to various details and unfortunately not able to follow up with much of it. There's much need for legislation and funding and everything else to get where we need to be.
Yes, okay.
that said,
Okay, let's go.
that said, Bill, if there's something you have to say, go ahead and say it.
I object, because I object to allowing public comment, because previously during other testimonies, I could have asked for public comment from officials here who could have
Yes.
collaborated, in fact, and because the hearing is only for the two, I was not given that opportunity.
So noted.
Okay.
Bill, if you want to share something later with me, not in our hearing, and then I'm more than happy to listen. Okay,
Better
let's
let it go.
let's
Yeah.
move on to Norm Warner. Okay, Norm, raise your right hand, please. Do you swear or affirm under the penalties of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, state your whole name, your full name, please.
Norman Clinton Warner III.
Okay. And Norm, you have before you the copies of the documents that you have filed with the clerk of Owen Circuit Court for candidacy in the primary election.
Yes, sir.
Have you reviewed those documents, and do you agree that they are the documents that you filed?
Yes, sir.
Okay. Are there any errors or omissions on those forms that you're aware of?
Yes.
Okay. Would you wish to clarify or expand the reason for those errors or omissions?
I missed the initial boxes on 7 through 13, I do believe.
Okay. And do you want to state a reason for that?
I overlooked them.
Okay.
Actually, when I read them, I thought it meant for a state or
Oh.
federal office, not the local one, so
Okay.
I mean, I marked some of the stuff in there, but I just didn't read it.
Just misread them?
Yeah.
Okay. Okay.
I also thought that the signature at the bottom kind of took care of that box, but obviously that's not the case.
Okay. And I'm just going through to yours real quick here. Make sure I'm reading hers. Okay. One more. And she has, she being Pam, has cited item number 1, or circled number 1, affirming the statements made in the statement were done under oath. That's on the can 2. And on the can 2, let it be noted that the filed and the Owen clerk's signature is on the front, on the very first page, not in the signature block on the second page. Okay. Then she has circled item number 2. Candidacy document needs to be completed and if applicable notarized, since a notary cannot notarize a signature unless the individual is present and signs a document before them. So those, that again relates to question number 1, or paragraph 1. She then contends on, has circled item number 4, the placement of any individual on the primary or general election ballot may be challenged if the individual has not complied with requirements set forth for candidates under Indiana law. And then number 6, declaration of candidacy for primary nomination, list of candidates, certification highlighted as a standalone, outline blocks 7 through 13. Specific questions, each candidate must initial and sign under oath. When these questions are not completed, the candidate has failed to complete the form. Failure to complete the form and declaration. If they answer untruthfully, this is a violation of the sworn statement. And finally, number 9, Can 2 may not be amended, thus not completing the form and failing to answer all questions. Complete and true is the same as not completing or filing requirements according to her contention. Okay, you've already brought up the missed or initialed spaces on question 7 through 13.
Yes, sir.
And if I understood your comment correctly, you, at least in some of those cases, you thought they applied to state office?
Well, you know, it says does not, and it's underlined. I should have, seen that, but
Okay.
by no means was it intentional.
But that was an error on your part?
Absolutely.
Okay. No intent
No.
on withholding any information, according to you?
No, I can assure you, I would have just as soon had it right, not been sitting here.
Okay, gotcha. Thank you. And you did, of course, read this statement, says I certify that the information in this declaration candidate is true and complete, and that I meet the specific requirements of this office.
Yes, and because I didn't think I had to mark those, that would be true.
Okay.
In my mind.
Gotcha. Okay. Any questions, Frank?
No, this is similar to what we've seen before.
Right, correct. Okay, all righty. Would you like to make any other statements on that, Norm?
No, I'm fallible just like everyone else.
Okay,
I should have read it more closely and got those checked off, and I didn't.
okay. And I did notice that all of the boxes were checked on the CAM 12, so that's not an issue.
We do have this issue of Lori appearing twice as a treasurer.
Correct. So,
I
I'm sorry.
can speak to that if you'd
Yes.
like. So if you'll remember, Tony, when I first started running, we put Lori as the treasurer. I then found out that I can be the treasurer and not have to bother her or bring her down here to sign.
Okay,
So that's what I've done.
okay.
Plus, if she's my treasurer, she can't be her own treasurer,
Right.
which we also just found out. So we'll take care of that, depending on what you guys do tomorrow.
Okay.
It may not matter, but
So the CFA 4, I mean, the CFA 1 can be amended. It's the CAM 12 and the...
we have a
Okay,
finance, pre-primary finance paperwork that'll have to be turned in before April the 17th, I think.
That's right.
And we'll get that fixed on that.
okay, very good. Thank you. Okay. Any other comments or questions?
No, I mean, you guys both know me. I'm not trying to pull the wool over anybody's eyes. Just missed it.
Okay.
Simple as that.
Okay. All righty. Thank you, Norm. And I'll go ahead and invite Pam up.
Thank you. Unfortunately, I have to repeat all this because each testimony stands on its own. So before you, you have a packet of exhibits that I'm presenting in this testimony. I also have, and you will be given a copy of my speaking points that I'm using during my testimony regarding my challenge against Norman Warner, spelt correctly. The items you read off, 1, 2, 4, all of those were read correctly, and I enter into evidence as what I did present. Makes that go quick. Regarding Mr. Warner's challenge, you have in front of you your packet, so if you here, we can walk through that. Before I start, the one comment you made was regarding the CAN 2, that you noticed that a file stamp dated January 8th contains Diane Stutzman's signature. Again, this is not a signature, this is not a wet signature, this is not a signature that is acceptable by the state regarding sworn and subscribed before me.
Okay, hold on just a moment. Deputies have the authority to use the clerk's stamp as a signature under these circumstances.
Yes,
Is that
now
correct?
there's a difference between a signature stamp and the stamp the office uses to record the document being filed and all. The question is here going to be for the board, can there be an interpretation reasonably from the documents provided and the testimony that the candidate was in fact aware of the fact that he was swearing under oath and that the attesting official was a governmental official as is asserted here?
Okay, thank you. Go ahead, Pam,
Okay.
sorry.
So I would agree with that interpretation and would expand on that, although it might be a reasonable interpretation, when it states you were subscribed and sworn, and when anyone in that office asks those questions, if you're asked, if you certify, if you swear to this, that is where you put your date and time and signature. So not only is it no date and time, there is no signature. So that is grounds that have withstood challenges at a state level for other CEBs for rejection of a CAN 2. but let me go back into my track of speaking. Can 2 was filed on January 8th, 2022. Now we're going to the 2022 document.
No.
Let me confirm it. Let me confirm that I did not make a typo.
Do you mean 2026?
No, you have both, so we have yes, I'm reading that wrong, my eyes are getting up. So that is January 8th, 2026.
Okay, thank
He
you.
failed to answer questions 7 through 13. He did, however, check number 12 as yes. The CAN 2 is not a correct and legal document. It's a requirement that this CAN 2 be certified and attested to the declaration of candidacy as being true and complete, and sworn before either a notary public or other official administering the oath. And again, it is the duty of the person who has presented the document to check and make sure that this is all completed. You are given a copy of the documents. And Linda, when I filed mine, specifically said, look over them. Do you see any mistakes? She was very clear on that. That's an opportunity to correct these problems before they occur. There's no signature or even a timestamp on the document. By timestamp, I mean a filed stamp is different than the timestamp. Whenever you walk in, the first thing they do is hit filed, or the sequence of doing this, you're not given the test, you're not given the sworn statement and then the stamps are put on, at least not with mine. So that may vary, but that's important to note. There's no wet signature from the clerk, and when they use Diane's stamp, the clerk or Linda will initial. So she's initializing using a stamp. There's no initialing on this document to show that this was done by the clerk deputy. From this, it shows that Diane Stutzman did this. She was not present, I don't believe. She might have been, but there's no initials. So it's even, when you say this was accepted by Diane Stutzman, just as in my other complaint, unless it's signed and there's initials, you don't know who was there or if that person who was in that office at the time actually did that. Each candidate is instructed in their manual as to how to file these documents and to check each mistake. When you go in to file, she hands you little colored flyers that tells you, here's what you need to make sure you know on campaign finance. Here's what you need to know as a candidate. When I went in first, I'm new at this, and that's what got me started into looking into these other people, not to be a nosy neighbor, but it's because this is my first time. I wanted to see what people in office had done and learn and follow their experience. And that's when I saw all of these terrible mistakes and had to take initiative and get counsel to find out what the correct way was to do this. Per Exhibit 1, the statute clearly identifies that the candidate must separately initial each statement required in this subdivision. It's not a may or should. It is a mandatory must statement by state statutory reference in Exhibit 1. The requirement to initial each statement serves as evidence that the CAN 2 was not true and complete, and he knowingly made false statements when he signed under a sworn statement. Now, he states that it was just a mistake, that when he read that, he didn't realize it was, well, I don't want to quote what he said, but he said it was a mistake, he didn't realize something at the time. When it says bold right above your name that you are certifying this information, you read the entire document that you sign. He did not. No CFA 1 was located for the CFA 4 filed on January 8th, 2026. Without a CFA 1, a true history can't be obtained. The clerk's office looked and did not find a CFA 1. Errors appear on the CFA 4 schedule A1 and A2, as the dates and types of contributions are not true.
Yeah,
Okay,
I think she's talking about for the previous.
Right. For the CFA filed on January 8th, that CFA is referencing and alluding to the CFA1, which was supposed to have previously been filed, and that record does not appear. So without the CFA1, a true history can't be obtained. So errors on the CFA4, Schedule A, 1, and 2, are dates and types of contributions are not true. Now, is this an error? Apparently. But it's the responsibility of the candidate to know their requirements for reporting these fiscal numbers. Again, that is another hearing that you've already alluded to address this matter, so I won't dwell on that, but it is a requirement when the CAN 2 states that you are aware of what the campaign finance statute is and what is required. Then the CAN 4 reflect, or the CFA 4 reflects that that candidate apparently did not implement what was attested to when they signed their CAN 2. Although an amended CFA 4 was filed on January 8th, the reporting period continues to be incorrect. Without evidence of the prior CFA 1, line 14 is not reported correctly, nor the dollar values entered into column A. When you look at that, you'll see highlighted the specific errors and mathematical amounts. On January 8th, Lori Warner is listed as treasurer. This is important. The CFA states the original date is 1/1/26. This conflicts with the CFA 4 reports. Again, numbers don't align and reports are missing. On February the 20th, a CFA is filed. Now, this is an amendment. Or no, the CFA 4 is filed on February 20th. It lists Norman Warner as treasurer. Signed and dated December 27th of 2025. It's filed 2 months later. Now, statute says that has to be filed within so many days when there's a change. So under his own documentation, he has signed it and dated it 2 months prior. So it is absolutely impossible to track which document is a controlling document because the dates skew how this all aligns. On January 28, 2026, another CFA 1 was filed. However, it failed to identify 11, 12, 20, 31, or Section D. Norman Warner is appointed as treasurer in this document. However, it's not identified to be an amendment. So this appears to be not an amendment to his CFA 1, but it appears to be a new CFA 1. These are all important facts as you go through and you audit this. Although several efforts were made to amend deficiencies, there was no effort to correct the incorrect annual reporting periods. The committee organization date was not completed in the last amendment, which further identifies knowledge of prior incorrect dates and how this impacts the CFA 4. I emphasize that because when these reports are missing and you don't put a date in, then your board would have no way of knowing what's deficient or defective. You rely on this statement made by your candidate that they know the laws, they know the rules, and what they give you is truthful. It's challenging to know what is a mistake or what is intentional. When leaving certain things unanswered, then it's ambiguity. So you can't enforce something. You can't say you have a defective filing when you don't list a date or you list the wrong date. Emphasis: when a treasurer is changed, then an additional report is required within 10 days of amending the statement. So where they said, okay, Lori was a treasurer, and then, okay, Norm said, okay, no, I'm going to be treasurer. Well, not only do the documents not align, but then this triggers a new CFA 4 to be filed within 10 days of changing the treasurer. This is an important thing that many of your candidates are missing in their documents. Is you change that treasurer, then that's the only way. If this is by law, you have to have that other report generated. So on January 28th is the date the last CFA 2 was filed, requiring a report to be filed no later than February 7th. This is a missing document. It was not done. He knew the report was not filed, thus in not answering questions within the CAN 2, allows him to file without jeopardy of perjury. So when a candidate fails to answer these questions, then the recourse to hold a person accountable cannot be applied, because they're not swearing to an oath that these are true and correct. When there's no answer given, then that person cannot be held accountable for making a false statement. Thus, it's a form of a creative way to not be held accountable. I submit exhibits A through I to support the statements made in my CAN 1 challenge. I request my challenge be upheld, as he has not executed a true and complete CAN 2 signed and certified by an appropriate party. And I have for you copies of my speaking points. I would have had these for everyone I did today.
Thank you.
But I ran these out of one of the printers in the library.
Norm? Oh, I'm sorry, Pam, were you finished?
I'm just going to give him a copy of this and then I'll sit down.
Okay.
Here's a copy for you, sir. And again, I wanted to reiterate one last thing. None of this is personal. I personally really like Norm. This is just a matter of business and paperwork.
Okay. Thank you. Norm, would you like to rebut?
Sure. So, the contention that I did any of this on purpose, didn't sign the CAN 12 to cover for something that I don't even know I didn't do, is preposterous at best. There is a CF4 that I had to do when I was caucused in, if I'm not mistaken, and it may be one of them that's in the mix here. So honestly, after that, I don't know which CF4 I do need to file, so I guess I'll take care of it when we do the pre-primary if needed.
Okay. So I have a question for you with regards to that. You did not run for office, for this office
No.
in a prior election. You were caucused in.
I was caucused in, yes.
And in that situation, you did not file a CFA 1, you just simply filed a CFA 4.
Okay.
Is what you're telling me.
I filed whatever they told me that I needed to file in order to be in the caucus. So if it's a CF4, then yes.
Okay. Well, I don't think that was the CFA 4. I think that's the, I forget the number on it, but it's the request to be considered in the caucus, and I can't remember the number on that.
Right.
Is it? Yeah, CEB 6 perhaps?
Right.
Something like that. Yeah. So it probably was not, unless you had a campaign and money, then my guess is it probably was not a CFA 4 form that you filed. It was probably the request to be considered in the caucus.
Okay.
Does that sound?
Yes.
Correct? Okay.
Right.
Did you collect any money for any materials?
In a previous campaign, I did have an outside donor. Most of it comes from our pockets.
Okay.
But not for this one.
But not for this
Not for
office.
this one, no.
Okay.
And in fact, I'm gonna go to the bank and make sure that everything's square there as far as treasurers and stuff,
Okay.
because
gotcha.
I wanna get it straightened out if need
Okay.
be.
And then, so just following up with that, since you did not run in a campaign,
Mm-hmm.
you did not, and I don't want to put words in your mouth.
Mm-hmm.
There was no packet handed to you.
No, and that's
to
the other
con-
thing. We printed ours from the state site at home and filled them out. And then came in to sign and get them
Okay,
notarized or whatever they call it.
okay,
So that booklet, I mean, it's on the state side. I mean, I've seen it on there. The finance book,
gotcha.
or the candidate booklet is there, but
Okay, okay. So, and where I'm going with that is, I think it's, if a person is not filing for a candidacy, then it would certainly be understandable that they didn't file the correct candidate
CFA
forms. Yeah. Because they were not filing for a candidacy, they were running in a caucus, and they were appointed to an office.
It's a nuance I want to look up.
Okay, gotcha. All right, any other questions on that?
No, I mean, it is what it is.
Okay. All righty. Okay, thank you, Norm.
Yep.
Pam, did you have a?
Yeah, quick rebuttal.
Okay.
Norm filed a CEB 4 that was on May 30th of 2025.
That was the one I was thinking.
And that is his appointment. Okay. Now, just a few days after May 30th is when, in that 1 month period, that the law changed and that the notices were sent out informing candidates who were in office that they had to reestablish their committee.
Okay.
Now, prior to him being caucused in, rules were different for that particular scenario.
Okay.
But he got notice that, hey, you have to do a CFA 1. And when he filed his CFA 4 on January 8th of 2026, he shows a reporting period from January 1st of 2025 through December 31st of 2025. This is indicative that he's saying that he had a committee in place for that year. So it's uncertain. Did he have a committee? So since he has run previously for many different other positions, he could have had a committee in place. So when I referenced the earlier CFA 1, it's not specific for what he was caucused in for, but since within that year he had run, that's a gray area. So it's understandable that mistakes could be made. But in January 8th, it's reported as a annual report, and at that time with Norman Warner as the treasurer.
Okay.
Then the CFA 4, next one, shows again January from 2025 to December 31st, 2025. But it has to, that date of when this report for has to reference a committee and a committee date.
Okay.
The first time he files the CFA 1 is on January 8th. And that is for a committee that, again, the dates don't align. He says the date of this organization is 1/1/2026. Now, the law says if you're in office and you're running for office, especially if it's a different office, like Mr. Hobbs, you go in and you amend your CFA 1 to show that you're running for sheriff. It's permissible to transfer funds between those, and they encourage the candidates to have like an easy transition, but your dates have to align. And so when he says his organization date's 1/1/26, he can't use CFA 4s from a year before for an organizational date that wasn't there. When you look at the February 2026 date, again, this is an amendment. Mathematics don't add up. So in trying, it's obvious that Mr. Warner has tried to make amendments, but unless you sit down and you have all of these documents in front of you, it's challenging. This is why the election office and the states encourages every candidate to not rely on friend or family to follow, complete, and understand these documents. They're complicated. They recommend you to get counsel if you're uncertain. Ignorance is no exception. When you make things like not completing a Can 2, that's something that can't be reversed. So thank you.
Thank you.
Real quick, my committee's been the same committee since 2019, when we first started that caucus. That's the first time I've ever been involved in any politics. I haven't changed committee. The committee has been in place the whole time. I've transferred the funds as needed.
Okay.
Just to whatever position I was running for. So I guess maybe I didn't understand, I have to put an organizational date on that.
So
because I
the
figured
CFA4 form that you filled out, first let me ask you this, when were you caucused in?
May 29th.
May 29th. So the CFA form that you filled out showing the funds in that committee, that was from the committee that still existed, only you just changed the office you were running for.
Correct.
Did you note that on the form?
I'm not sure.
No? Okay, okay. But the dates of that, January 1, 25 through December 31st, 25, would have applied to that committee and any corresponding funds in that committee?
Right, and that's why I did it that way, because that closed out last year.
Okay.
I wasn't running for an office yet.
Did you file that as a complete, as a closeout? Did you check the box that says I'm closing out this committee?
I don't know, Tony, I'd have to look at it.
Okay.
But do I have to close it out and then reopen it every time? I
You
guess that's-
you don't have to, you have the option to close it out if you
Okay.
choose.
Rebuttal. On January 27th, 2023, on the CFA4, oh, I'm sorry, wrong person. I withdraw my rebuttal.
Okay, thank you. Okay,
Hopefully that's clear.
yeah,
That's my thought process. I never closed it out. I just wanted to use that committee for this run.
okay. And so when you filled out the new CFA1 form, you're using the same committee name,
Correct.
but you've changed the office that you're running
Yes.
for? Okay,
And I think I noted that on there, that I changed the office. At least I put the office I was running for on there, I thought.
it just says committee to elect Norman Warner III. It doesn't specify what office on here, on this CFA form.
Is there a spot for that?
You could have put that,
I can put it on there, but is there a line for it, I guess is what I'm asking. Maybe I missed it.
no, the way I read the form is that is in the full name of the committee. You can set your committee to say, committee to elect Norman Warner III, or you can say, committee to elect Norman Warner III as county commissioner.
Well, right, but
You know.
I kept it just as Norman Warner the third,
Okay.
because then it's not specific, and I can
Gotcha.
continue to use that
Okay,
committee.
okay. The error that was on here, that you had already made a previous statement that you weren't aware of, or at least Lori made a previous statement that you weren't aware of. It did list Lori Warner as treasurer. Once you realize that you cannot be a treasurer on both, then your intention was to change that.
Right.
So, which would require a new CFA form,
Right.
a new CFA1 form, declaring a new
I'm gonna go to Peoples and make sure what we've got down there, and if it's not right, then I'll put me on it. We'll have to probably fix hers too, I don't remember what we put on there. And then I'll CF4s that will reflect what we
Okay.
know is to be accurate.
Okay, thank you. Did you have any other questions?
Nope.
Okay.
I'm good.
All righty, thank you. Thank you, guys. Enjoy what little bit of day you got left. All right, who do we have next? Okay, Dusty,
Yay.
and you're it, right?
Am I?
Let me look, I think
I
so.
think that's
The
it.
one you guys have been looking for,
Well, there you go, all of
the
it.
last one.
Okay. Dusty, do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Okay, and could you please state your full name for the record?
Dustin Mitchell White.
Thank you. And Dusty, you have before you the copies of the documents that were filed with the Clerk of Owen Circuit Court candidacy. Would you review those documents and determine whether they are true and accurate copies of the forms you filed?
Yes, they are.
Okay. Are there any errors or omissions on those forms?
Apparently.
Okay. Would you like to clarify or expand on reasons for those omissions?
On, let's see. Let me find them here. Yeah, the Can 2, 7 through 13, I did not initial those, but I did sign.
Okay. do you have a reason that you did not?
I don't know. I signed it. I didn't realize I should have initialed it.
Hmm?
I also have a can 4 and a can 12 that I'm can turn in, or if it's acceptable.
Okay,
An
so,
amendment for a CFA 4 and then the can 12.
okay, and the Can 12 was not submitted with the Can 2, correct?
Correct.
Okay.
Why didn't you file the Can 12?
Great question. I didn't realize I needed to file that at the time.
Okay. All right. And the clerk was, or her deputy was present when you filed the Can 2, correct?
Yes.
Okay. And she did sign in the appropriate space on those. Okay. So the primary contentions, I believe, that will be challenged are the fact that you did not initial or check the boxes in 7 through 13, and you did not file a Can 12 with the Can 2 when you submitted it. The CFA 1, let's see, as respected packet, and those are made in this record. The CFA 1 can be amended, but the other ones are requirements. 2 and 12 by statute has to be filed with the Can 2. Okay. All righty. And on your CFA 1, on your CFA 1, there were several things missing.
Yes.
And who you were going to appoint as treasurer, et cetera.
Yes, but
Is included in that.
so I've never taken any money, nor do I want to handle any money. So I don't really have a committee. This is a formality, kind of.
Well, did you?
Could be.
Right.
I don't know how.
So my understanding is if a person spends 500 or more on their election, is that not correct? They have to file, even if they don't collect it from an outside?
Correct.
Yeah, I mean, if you fund your own campaign, but you spent money, at least I always was under that impression, and
I
I
haven't spent
filed
any
my
money.
own. Oh, it did change, okay. Pam is telling us that it changed, so,
I'll
okay.
address that.
Okay, so she will address that in a challenge.
$0.
Okay, gotcha. All righty. Okay, any other comments or questions that you would like to make? Okay. Having said that, we'll go ahead and have Pam come up and state her challenge.
First comment is, thank God this is the last one.
Yes.
I have submitted documentation before you that will serve as evidence, and I also have copies of my speaking points that I will give you when I'm done. To first address clarification. $100 is the limit now. If you will receive donations or you expend even your out-of-pocket loan of $100, that's the threshold amount.
Okay.
Then it further states, on, let me pull up his thing here. That's why filling the back out of your Can 2s are so important. It states that if you will make more than $5,000 per year in the office, that you are required to have the campaign finance or the CFA ones filed. So that's number 13 on the back of the Can 2. And I'm sorry if I mix my numbers up, I'm getting tired.
And let me clarify on that. It requires you to file the CFA 1, but not a CFA 4.
Right, so the CFA 4, it's $100, and I had to
Right.
double check that, because it even states down that you have to get an FEIN number, that you're not allowed to even hold cash. So you have to get an FEIN number and establish your account. So these are all things that I'm actually trying to look into in detail if needed for me, because they change. And that's why the clerk's office and all the documents tell you to look every year, the manuals and the records. There's some changes, and you can't assume what you knew from a few years ago to apply now. It does change.
Okay.
And I agree with the statements that you read, 1, 2, 4, 6, 7, and 8, and 9 as to the Can 1 I filed. And regarding Dusty White's Can 1 challenge, he filed his Can 2 on January 7th of 2026. He failed to answer questions 7 through 13. Per IC 3827, Declaration of Candidacy, Contents, Exhibit A states, the declaration must contain the following information. 7, a copy of economic interest. File stamped by the office required to receive the statement of economic interest. A circuit court may reject a circuit court must reject, a circuit clerk
Yes.
must reject a Can 2 which is filed without its attached proof of or actual economic interest statement. So I would like to emphasize that, because there is no, some of these documents you can amend if you have a scrivener error, but you cannot late file them. There was no required Can 12 filed. And by statute, the clerk must reject the filing. Again, as I mentioned earlier, it doesn't state when that rejection occurs. Is it done during this hearing or at another point in time? But for that grounds alone, there is no statute that provides for any late filing of a Can 12. Dusty failed to file the Can 12 with this Can 2, and as of 2/23/26 noon, no Can 12 had been filed. There's no exception. He may not appear in the primary as a Republican candidate for the assessor of Owen County. That does not mean he cannot refile and run as an independent, but he is excluded from appearing as a Republican candidate
On the primary.
on the primary. Furthermore, on page 2, Exhibit A, it further identifies that the candidate must separately initial each of the statements required by this subdivision. Dusty failed to initial any questions 7 through 13. The requirement to initial each statement serves as evidence that the Can 2 was not true and complete, and that Dusty knowingly made a false statement when he signed under a sworn statement. Now, had he read what he signed, he would have read in there that it says, like, warning, warning, you have to file your Can 12. So, as I earlier alluded to, by not checking or initializing any of those statements, this is a catch-22 that a candidate can use to say, I wasn't informed, I didn't know. It's there. You read it, and that's why you initialize it. There's a purpose behind that law. On January of 2022, and 2022 is correct, Dusty White again failed to answer questions 7 through 13 with his Can 2 he filed when he ran for office, for the office he's currently holding. So, as it's recommended that you review your documents, he had 4 years to check, to confirm, and to review his information and to use that as a standard. So, 2022, he didn't complete the Can 2, but no challenge was filed. Challenges can only be filed by people who are eligible in the particular area that that person is running for. So this is one of the motivations for me to file so many challenges this year, is because things have slipped through the cracks for years, and this particular thing of not completing those questions is a snowball, because it allows a candidate to avoid accountability. That's what is really necessary. So on January of 2022, Dusty filed a CFA 1. He failed to designate a principal committee. Okay? Again, those questions he didn't answer explains you've read finance law. You understand what's required of you. So he didn't designate a principal committee. He's had no principal committee during that time. Section B was left completely blank. He therefore did not meet the requirement to establish a statement of organization, invalidating the CF1. So if he doesn't establish a principal committee, then he has failed to establish his organization. That's by law, you have to do that. No chairman was appointed, thus no treasurer could be appointed, and only the chairman may appoint a treasurer. So that's 2022. Now let's go to January 27th, 2023. A CFA 4 was filed for a committee which was never established. See line 13 of the prior CFA 4. And I want to double check the date on that because it says 2023. Oh, that's correct. See line 13 of the prior CFA 1. This is a fictitious report indicating it to be a post-convention and final line 11 report. He indicates this report was through January 1st of 2023. The facts and the details speak for themselves. A post-convention CFA 4 is completely different than what's required for CFA 1. On June 24th, 2025, Dusty does file a new CFA 1. He followed the rules of, if you don't have one, let's get one filed. But again, he fails to answer number 20 through 28. Didn't answer one of those. And it didn't answer number 32 nor 42. This is an incomplete document with no standing, and again, without naming a chairperson or treasurer. As he does not provide a committee organization date, his CFA 4 filed document on June 24th of 2025 absolutely cannot be truthful. When you review this, this is not a mistake. This is a document filed that cannot be truthful. A report filed on June 24 states it's for January 1st of 2024 through January 1st of 2025, but there was no committee in place during that time. He was informed to file a new committee, CFA, since he had closed his prior committee down. The new committee would not be in effect until the date of filing, which was June 24th of 2025. So how can he say that his CFA 4 is for a time period when there was no committee? The CFA 4 filed is false, and I direct you to the warning at the bottom below his signature. And I emphasize that heavily because it is in bold. It informs the candidate when they sign what it is they're signing and what the penalties and repercussion for making false statements or signing a document known not to be correct. On January 7th, 2026, Dusty filed another CFA 1. Once again, he does not include line 20 or line 12, provides no signatures under section C, and a minimum of 1 signature is required. And he does not sign number 41. On January 21st, 2026, he files a CFA-4 for January 1st, 2025 through January 1st, 2026 as an annual report. He does not indicate if this was an amendment or the county of his residence in number 10. And the CFA-1 filed on January 26 states that this is not an amendment. However, he again uses a different committee name on line 13. So he has multiple committee names, documents that do not align. Further, Exhibit B provides Indiana code for the requirements I have stated in my challenges. Pages 1 through 4 specifically address these details. I submit Exhibits D, E, F, G, H, I, J, as well as my previously referenced A, B, C in support of my Can 1. I request that you uphold the Can 1 challenge to allow this person on the primary ballot. He should not appear. In addition, if the CEB does not uphold this challenge, I ask that you conduct a full investigation into the content, truthfulness, and intent of the documents submitted to appropriate bodies to facilitate a comprehensive investigation into this matter. A failure to submit a Can 12 at the time you file your Can 2 is a required rejection by the county clerk to allow this candidate from appearing on the primary ballot as filed. And one additional comment is that when Dusty did not answer 7 through 13 in his 2022 filing, a significant correlation exists between he did not have required certification to attain the office of county surveyor. Per 36-2-15-2, Dusty was required to be a level 3 assessor appraiser before January 1st of 2023. He was caucused in back in 2022. Since he served in that position for almost a clear year, the law states that he must have his level 3 certification before he is appointed, or not appointed, before he is to take office. He obtained his certification on March 28th of 2023. Law provides that his salary can be withheld and there's other penalties that's in place. Now, I believe that Dusty will have an explanation as to why he didn't have his certification until almost 4 months after he took office, having to do with timing of courses. In conference with DLGF, it was stated that he was eligible and could have taken his certification when he decided to run for that office. When he filed his Can 2 in early 2022 for his 2023 office, had he signed and initialed in the back, he would have known, hey, you have to make sure that you are certified and qualified to take your office. So this is where I propose that not filling out the back of your Can 2 facilitates. Some people, it's absolute mistake. I believe that. I cannot make that assumption or that outcome for everyone, because since it's blank, he cannot be held for perjury of certain statements. And did he knowingly know at that time that he wasn't going to get his certification? I can't answer that. But knowing that that is a statement that you sign, that you understand that you may have to receive certain trainings or certain certifications, and you must know what is required for you to occupy that office. And he knew at that time what was required for him to occupy that office, and he
With all due
disregarded that.
respect, I don't think 2022 is at issue at this point.
2022, he was caucused in.
I understand that, but I don't think that's an issue in the matter before us today. That should have been perhaps an issue in an earlier challenge.
Had it been
I'm
challenged.
only bringing this up to allude to the current Can 2, which emphasizes his failure to answer any of those questions
Which
and
which
how.
must be evaluated on its
Right.
own. But
And-
2022 is not relevant to this particular
It
hearing.
does relate to
And we're
prior
offering to training,
documents.
well, no, it does, but the evidence that you've brought forth here today on 2026 filing is absolutely to be considered.
Right, well, inclusive through their current office, because these questions on the Can 2 relate to
I
their
understand your
current
point.
office.
I
And
understand your
with
point.
that, his current office, he did not hold proper certification when he took office, so it is relative.
I
But thank
understand
you.
your point.
Okay, rebuttal, Justin? I have a question on that as well.
Thank you.
Did you have a question?
No,
I think,
I had two, oh, no, that was full. Okay, so,
Thank you.
there is a requirement for the training, but they give you a certain amount of time, is that
So the
correct?
requirement for the training, you've got to be a level 2 to run. You've got to become a level 3 within your first term. That's how it reads. With that, I was caucused in and had 1 year to do it, not 4. In that 1 year, there's 5 classes to take that are a week long and 5 state exams. Not even all those classes were available in-state. This is all post-COVID, a lot of questions. I had to take a couple of them online. I didn't get it until March.
Okay.
But they didn't offer the classes to take anywhere that was reasonable.
Okay. Okay. That was your
And just
question.
for the record, I am currently a level 3.
Level 3, okay, all right. I think that was the only question I had. Go ahead with any
Okay.
other rebuttals.
Good point. She said, I've had the last 4 years to use as a standard. Her words, use as a standard. I filled them out the same way. I'm not trying to do anything malicious. Those forms, the committee, I don't know how that works. I'm new to this. I don't have a committee. I would be the treasurer. One of those I signed as a treasurer, one of them I didn't. I don't know. I don't know what I should be doing apparently with some of this paperwork. But I'm more than willing to do whatever we need to do. I know we're past the time of that. I did file as early as I could in case there was something that I could change or could fix or, and all those things that she's talking about from 2022 and 2023 all went through. So
So what you're saying is, I did it that way last time, so I'm going to do that the same way this
Well,
time.
I'm not saying yes and no.
Yes,
Yeah,
I understand.
I did it, and I don't know. Yes, I'm not putting blame on anyone other than
Well,
myself.
that's not,
I
I'm
agree.
not assessing blame, but your thought process was.
My thought process
I did it
was
that
this
way
how I
last
did it.
time, and so I'm doing it that way this time.
Right, and it wasn't challenged last time, and so
Correct.
when
Right.
your statement, it went through, meaning that it wasn't
Correct.
challenged. Gotcha. Okay,
Okay.
that makes
Not
sense.
that that's neither here nor there, but that was my thought
I
process. I'm
understand.
not trying to pull anything over on anybody. There's no fraudulent activity here.
Okay,
I don't handle money. I mentioned that earlier. $0. So, to me, that's as important as the committee, but
Yeah, right.
if we're listening to opinions we have all day, it's my opinion.
Okay, all righty.
Does anybody have any questions?
No, I simply had a question on the training requirement, but
Yeah.
yeah, no, that's,
Just for the record, there's also counties with assessors that can't pass the tests, and there's nobody else qualified to run, so they
have not removed
they just
them.
waive them.
Right, okay. Okay, all righty. I didn't have any other questions.
That's all right.
Okay, thank you so much.
In a hearing, if I do not rebuke something that's said incorrectly, then that goes into record, so it's important that I do that. Dusty misspoke. To run for office, to run for a county assessor, you do not have to have a level 1 or a level 2. Now, this is not training, this is a formal level of certification. You must have your level 1 and level 2 before you take office. And you may run for that position without having any of those certifications, and the state facilitates all of their online training and testing to allow any person to run for that position without a level 1 and level 2 to help promote this office. Number 2, if you serve as an assessor, such as being caucused in, then you are required to have a level 3 certification before you take office. The statement about you have 1 year, that's not a correct statement. Had he not been in office before in that position, he would have 1 year. He was required to have it. Yeah. I would like to reiterate that changes have occurred. So when you make a statement as, hey, that's how you did it 4 years ago and no one said anything, and so now I'm doing it again, our election rules and public information has changed. There are manuals that are updated constantly.
Yes, I think we all concur with that.
Okay,
And
and then-
he was not justifying it, he just was giving his thought
I
process.
just wanted to reiterate that it's still the candidate's
Right,
responsibility to be informed.
he did not
Yeah.
dispute that.
And I would like to, where Dusty emphasizes that, hey, he doesn't bring any money in. When you establish your committee, this is not just a committee for your finances. This committee is established so if you go in and say, vote for me, Dusty White, for assessor, you have a t-shirt, you have a sign, whatever it might be. That committee and who the chairman is, that is all an intricate part of the rest of the process as to how you may advertise or campaign. It's not just about the money.
Right, and I think
Yeah.
the board understands that as well.
And the last statement is, Dusty made a comment that, hey, there's counties that the assessors haven't passed their tests, so they just give them a pass. There's a state law in place that says if a county has an assessor that has not met their qualifications, there's certifications, it's not training. Now, the DLGF may give them an extension of that time, but legally, during that time period, they must appoint from a budget a certified level 3 assessor, appraiser, to facilitate any assessments. These are like your property card changes and things that are going on. So it's the nomenclature is being correct or not correct. So I just wanted to have those matters go on to record.
Okay.
Thank you.
Thank you.
Okay, Dustin.
And once again, the level 3 doesn't affect this today.
Because you're
None of
already
it.
certified level 3 now.
Right.
Okay.
Nor,
Noted.
Yep, okay, thank you. All righty. Any other questions? Okay, then we are going to recess this meeting until tomorrow morning at 9 a.m. we will reconvene at that time, and then we will disseminate our findings.
We'll discuss and disseminate our findings.
Or discuss and disseminate, yes.
And that's a public discourse we.
That's right. These are not talked about by us after this meeting. We take our information home, we come up with our own conclusions, we discuss it tomorrow during the meeting, and then we will.
And we might have some questions for council.
And then we will vote on our findings through motions, et cetera. So speaking of motions, I'm going to accept a motion now to
I have a question.
Oh, yes.
Regarding that, so let's say a person does not attend tomorrow.
Uh-huh.
Will those parties receive some type of written?
Absolutely.
Absolutely, yes. Every one of our findings will be written and public record.
And about what is the time frame to provide, since there's a limited time frame as to an appeal process?
We have till tomorrow at noon.
Right, to make a decision, but to send out the written,
I'm not aware of the time constraint on that. My feeling is that we will get that out just as soon as possible, as soon as we make the findings and then the notes are transcribed and published, then we should be able to send them out.
We don't want to make any promises about what the mail would take.
Right, right. But yeah, it would be, pretty much immediate. I mean, as soon as the process is finished.
I wish to thank you. I was very wordy, and I appreciate your time and your attention to the seriousness of the matter.
Thank you.
Thank you.
Any other comments, Dusty, from your point of view?
Thank you very much.
Okay.
It's been a long day.
Yes. Okay, so I'll entertain a motion to recess this meeting
So
until
moved.
9 a.m. tomorrow. So
So
moved. All in favor? Oh, I will second that, sorry. All in favor? Aye. Any opposed? Motion carries. Okay.
Richard, mic off.
Is your mic still on?